Yes.
So in regard to item 52 supplementary, well, it is fixed at 2 p.m. Now the IA application filed by us, then today also it hasn't come, so your lordship can grant us so that it can be tagged with the
You have the number?
number is there. The time I'm giving.
Give a mention memo for that.
Apply.
Yes.
One is an appeal under order 41R
Hmm.
against an order not considering our application under order 13.4 on the ground that earlier an order was passed to keep the suit in abeyance.
I passed some order in this matter, no?
Earlier, but in this case, no final order was passed. But I just pray that from the other side also, I've read the matter because I didn't.
Don't worry. Will happen.
In item number 15, IA has been filed.
Item
on
number?
24. Item number 15, my lord. I will make call for.
Hmm.
It is not there. Item number
IA has been filed.
IA has been filed.
For what?
24.
For what? IA filed for what?
Order 39, rule 1.
That has not come in the list.
For interim order. For interim order.
We'll have it some other day. Second. Along with the IA. You have the IA number?
Not but filing number is there.
No. Mr. So-and-so, the learned counsel appearing on behalf of the appellant submits an interlocutory application has been filed. Is this first appeal along with the said interlocutory application on 2nd of April 2020.
Yeah, with regard to item number 39 of today's list matter, I am led by senior advocate in this matter for the respondents matter. This matter was initially fixed on Friday last because of the bench was not available. The matter could not be listed. I tried to make a mention on Monday.
Item number 39.
39.
What do you want?
An adjournment today.
Why?
Is the midst
Huh,
of a
huh, huh.
matter.
What?
Mr. Mishra is in the midst of a part-heard hearing matter.
Who is in bits of a partner?
PK Mishra, senior.
So how does it matter? No, Mr. Counsel, I don't grant adjournment for senior counsels. So don't come up with this type of adjournment.
In that case, you're also going to grant me at the second half. The matter may be taken up in the second half.
Will happen in the second half only.
Take to mention, Lordship, item number 3, Lordship, is from motion. Due to some personal difficulty, Lordship, I could not prepare the case properly, Lordship. May have some accommodation.
Request of the learned counsel for the petitioner, matters can be adjourned to be listed after. How many weeks do you require to prepare?
Some week, Lordship.
To be listed after 1 week.
Item 49, personal appearance partner.
Where is it here? So you see, I'm not understanding one thing. We did not call you for the other reason. The reason is this. Dog number 5 and dog number 49, isn't it? Have been taken. Is under the possession of the CRPF authorities. Okay. Now, you say from some of your communications that out of dog number 5, dog number 49 had come.
Document 49. There is the 5 public 49.
So it has arisen out of dog number 5. But you don't have a map for that. On the ground that no Vendic map have been prepared till now. That's what you are saying. But how do you identify dark number 49 then?
Tag number five, the area of the tag five is around like what we got, but the area of 49 bigger something. Arithmetically, tag number 49 cannot come out of tag number five.
Therefore, my question was, because initially was dark number 49, 5 contains so much of land.
The Venn diagram, this Venn diagram has been prepared during the settlement period. During the area around the 1770. So tag number five is clearly seen in the map.
Understood. But we see from the other reports which have been given and placed before this court, it is seen that there is a report from the circle officer to that effect earlier that the dark number 5 and 49 is in possession of them, of the CRPF authorities. You say so. On the other hand, the trace map which you have given is a lean strip of land which would suggest something like a lane more of it, because taking into account the measurement in which the land has been prepared, 1:16 inches into 1 mile. So it will be a very lean strip of land. So it can't be, as per the trace map, what your report was earlier. So there seems to be some discrepancy in this earlier report along with what you have given subsequently. There seems to be some discrepancy. Both can't gel together, if I'm not wrong. Because on one hand, you were saying earlier that they were in possession, and the question was whether there was any allotment made in their favor. Now they say that we don't have any document for that purpose. Now, if there is an allotment of any land in favor of anybody, there would be a beneficiary, or either you have to acquire the land from the government, from the private person, if it is a patta land, and undoubtedly it is a patta land. So, do you have any records for acquisition?
The records are in the
Because if it is still a patta being maintained, means it can't be a government land. So the government can't allot it to the CRPF. So the question of allotting to the CRPF does not arise. But the question is, therefore, if there is no acquisition, the possession of the CRPF over the land would be illegal. Isn't it?
records here.
Hmm?
That there is no record pertaining to any kind of.
So therefore, this land, I request you to identify this tag number 5 and 49 of his land. His land. Which you have stated in the earlier affidavit, affidavit has been filed earlier in this matter. So in consonance with that, file an affidavit bringing on record the area of the land which falls within it, and as to whether the CRPF is in occupation of the land. You can carry out these demarcation proceedings without disturbing anybody's possession, only to that effect, and file a report before this court along with that affidavit. Okay.
My lord, I'll just like to point out one thing. This is a copy of the Jamabandi. Yesterday night only I have downloaded it. Now, that number 5, my lord, it cannot be a strip of land. Because the lordship will see, my lord, from first, second, fourth from down below, my lord. Tag number 49, lordship found in my lord.
Dag number 49, it consists of 3 bigger, 2 kata, 9 letters of man, and the class of land it is Nova. It should be Notun, maybe Notun Bostu. And down below, Lordship will find Dag number 5, 1 kata, 2 bigger, 15 letters, it is Notun Bostu. So if it is a road, my lord, how in the Jamabandi they are recording it as my lord, is Nova, Nova.
No,
Yeah. And
that I know. That is not the question of that. Therefore, the trace map seems to be not in proper manner. It can't be. If you've seen the trace map, you have a copy of the trace map. See how you have put the trace map is something like this. Just a thin strip of land.
We have for records are digitized map also, sir.
Mm.
Yes, sorry. That village has already been uploaded to the sub portal, sir. But that sub portal, if you search tab number 5, then this particular script, sir, can be seen, sir. Tab number 5 can be seen as a and
Now that I understand. But how is it possible?
record. Here's a video.
You are just putting it on one hand, your identification of the land earlier was different. And if you are putting this tag number 5 as a strip, and it is of a dimension of the area of 1 bigha 2 kata 15 lecha, the strip of land will be a very long strip of land. You understand this? Because the area would be so the area would be around 22,320 square feet, which is a huge area. And then if that is the strip of land, I think it will cover the entire land. And this will encompass many other lands nearby, which will create a huge problem for everybody. Don't you think so? If this is the map you are saying, because you say that this entire, because it runs, this dark number 5 runs to not only that, it runs to many other darks nearby.
Seven 38.
How many darks are there in the meantime? If you see, it will be that strip which will be near to dark number 6. It will be bifurcating dark number 6 and dark number 39, 37. Isn't it? So it will create a huge problem if this is the map, which can't be so. And where are they? The what you call the CRPF are there. You can identify that by making a clear-cut demarcation to the effect that where are the CRPF located, and make the demarcation and come back and submit a report before this on an affidavit. As to are they in occupation of dark number 5 and dark number 49? Please look.
One more. One thing, last location they have filed a report. So this report actually, what they have said, they have not given about details about 3 bigha 1 kata 19 letters. Initially, it is clear in the Jamabandi matters. Initially, it was patta number 6. Thereafter, totally it was 150 because between the family. So up from that number, patta number 6, it came to patta number 31. So this is the Jababandi of patta number 31, and there are 50 bighas of land in patta number 31. So some land they have sold or something like that, and the dispute as regard the occupation of CRPF is 49 and 5. So it is clearly written in the Jamabandi matter that it, that number, patta number 31 has emanated from patta number 6.
The total land out there is around 47 bighas,
No, that
2
is
kata,
wrong,
13
my-
acres. No, no, patta number 31 contains 47 bighas, 2 kata.
50 bigha, 50 bigha.
You see this
Yes,
this document
yes, ma'am.
goes down there.
Because
47 bighas, 2
the
kata, 13
second
acres.
page your lordship will see, Jamabandi matter. Moot past third paragraph. Moot 50 বিঘা জমি বাটোয়ারা মরবে পট্টাদার সঞ্চয় নীলাচল রয় ভিজা নিকাল রয় নামত নতুন 13 নং মেয়াদী পট্টাভুক্ত করা হয়।
No, no, that is okay.
Yes.
So they make 31.
13.
And I think now there might have been further bifurcation of the patta.
This is the
And therefore
latest
now,
Jamabandi which is available.
so
in the
therefore
website.
now, you see the last page of
Yes,
the
that is 47.
it shows that 47 bighas, 2 kata, 13 acres.
These were the details which they have. As per this, the communication which was sent on last occasion, my lord, it comes to 46 bighas, 3 katas, 11 letters. They have not considered these 3 darks, 55, 56 and 58.
So the patta, it has a revision from patta number 6. And bifurcated by
This
taking out 50 bighas.
50 bighas in the name of these 3 petitioners. This,
What are their names?
Charlene Nichols Roy, Riseda Nichols Roy, Celeste Nichols Roy.
So they are the owners.
Yes, they are the petitioners.
And then they have transferred some land.
Some land they have sold. Now, these 49 and 5, these are in occupation of CRP. Now, had it been a road in this Jamabandi manor, the class of land, it would have been but not Nabat.
So it's okay. I think this is the best way is to go for a demarcation of the land where the CRPF is. And then get a report. And on the basis
The
of
earlier
that,
affidavit, my lord, in the writ petition there.
that I've seen it. I've seen that. So therefore, let him come up with a report.
Yes.
And place it before, because this dark number 5, what he is saying,
And
may
then it
have a
cannot-
lot of
Yes,
ramifications.
it cannot be.
So let us have that. And let him give up, because he has to identify 49 somewhere.
Company.
49 is there, there is no quarrel that it has a reason from dark number 5 as you say, but it could not have been. Because dark number 5 when it was created, this dark number 5 must have been created after the bifurcation of the patta number 6.
Yes.
Is
It is there in the Jamabandi, it is written.
Huh?
Number 5 is the original.
Understood, but was that dark number 5 there when the patta was patta number 6? So you have to look into that, because therefore you have to identify, how do you identify? To see the particular map, you will be aware that. You see the particular map when patta number 6 was there and it was bifurcated out and there was a partition and patta number 31 was taken out. Which were the darks at that point of time? And from that dark which was created, you will find it out there in your chita, the draft chita. And when this particular dark is being created, from there you will again find out whether from dark number 5, is there any bifurcation of taking out another dark? Normally from a particular dark, when it is bifurcated out, there is a partition being done. And when that partition is being done, it leads to a coming into effect of a new patta. But I don't understand how a diag number 5 can be partitioned out and brought 49 without there being a separate patta. Because that is not done, because normally the dark numbers are being put during the time of resettlement operation or settlement operation. So therefore they put this dark. But when you make a partition and take out something, then you have to give a patta. It will lead to a fresh patta with a fresh dark. Maybe the dark remains the same, but the patta will be different. That is how it happens. But when you are bifurcating dark number 5 to 49, it becomes a very difficult thing to understand. Because that is normally not done as per the rules. So you,
How,
madam, you help in the demarcation. Don't disturb.
But how this 49 and 5 has come up, if he can go, if he goes through this, my lord, case number 68 of 2004, everything is there in the
Which
Jama.
one here?
Yes, it is there. My lord, কামরূপ জেলার অতিরিক্ত উপায়ক মহোদয় 30/12/2004 তারিখৰ ইমান নং বছৰ. So if he goes through this case number, order dated 4/1/31/12/2004,
ছয় নম্বৰ পত্ৰৰ 5 নম্বৰ দাগৰ 1 বিঘা 2 কথা 15 লেখা 44 নম্বৰ দাগৰ 10 লেখা 6 নম্বৰ দাগৰ 9 বিঘা 2 দাগৰ বিঘা So these were inserted from not from
when
patta
this
number
six-
6.
When this 6 was converted to 31,
So this
and
happened.
these tags were created.
So here you get this. You have a
Everything
copy
is
of
there.
this?
I have given a copy.
No, this one.
Yes, I have given a same. Same. I have copy, but you also brought this.
Okay. From here you can make out.
Yes.
So therefore, it cannot be said that dark number 49 erases for 5 from this order. If it is right, written correct. It was brought from patta number 6.
Like the last that number is 37. So basically 49 would be the, it's a dark, I think newly created.
No, understood, but dark number 49 was there in patta number 6.
No, patta number, in 2005, this dog was there. How it can be newly created?
No. If you see this book,
Yes.
this document, it says about the patta number 6 as patta number 49 is there.
Which they have, it was in vernacular manner. I have just, for the sake of convenience, I have just.
Now,
made a-
here also you see patta number, this is a patta number 6.
So they say this is a patta number 6 initiative, because in this, my lord, this report which they have given it, so for convenience sake, I have just made out this chart.
No, therefore, patta numbers, so when patta number 6 was there,
It could be, my lord, not 31, my lord, it should be 31,
this was 31,
31.
not 49. So, but dark number
31.
49, but dark number 49 was all along there in patta number 6 also.
From this, my lord, order, it does not seem so, because it says that, my lord, that when 31 was created from tab number, patta number 6, then these tabs were created. That's like, because this is from tab 15 plus and 49 and tab 3. From second
No, pottat. No, you see the language. Hiraj Miadi soy number pottat, pass number dagor. So that means the dag is there.
in 6, yes.
So it is already there. So this also 49 is there. So moot 50 বিঘা মাটি জমিন বটোৱাৰাৰ মৰ্মে পট্টাদাৰৰ so and so লৈ আহি যায়. So that means these pattas were there in 6.
In 6.
So you have to therefore trace out from the trace map of patta number 6. These dark number 49 was there then. If we read this particular
order.
column, if I'm not wrong. So therefore 49 was there then
6, patta number 6.
in patta number 6. From there, patta number 6, when it was made 31, that 49 number that came along with 30. It seems this is the language. I don't know. These people may, while putting it, may put it differently, but you have to see this order which has been passed by the circle officer, by your predecessor.
But then
Hmm?
not by the-
Whoever it is, you just see this order. I think you'll get something from there. Hmm. You do one thing. Let me have it again on 21st April. You make this verification and then come back before this court. Or I think your presence in the court will be required because it becomes otherwise very difficult. I can have it through video conferencing. But the only problem is again, this has explained. So you come back and file an affidavit to the effect as to what happened from this order, what can be culminated from this order. And thereupon, as to whether dark number from pattern number 6, whether the dark number 49 and 5 came in. And you have to look into the trace map, earlier trace map, because that pattern will be there. You will have the trace map earlier. For pattern number 6, because they bring in exactly the same darks. So there you will get an idea from that map, the earlier map, as to how, what was there in pattern number 5 of pattern number, dark number 5 and dark number 49 of pattern number 6. Because that is being brought into 13.
Maybe, my lord, this,
I think that is a better.
when this patta was created, earlier dags remain. And that patta 6 has been given in respect of. some other
So this
language.
is how it appears.
Appear.
From the language out here, it appears that these were not creation of new darks.
In 6 only.
And thereafter, or do you want to go for this demarcation? Just go for measure. I think first you come up with this. We'll see later on the next day. Would 21st of April be convenient for you? Huh? Okay, when is the Panchayat election?
last part of the month of April, I think.
Huh?
So I think declared first week of
Okay, you do one thing. If it happens so, you intimate him about this thing, and then we'll take up on it. Okay, but you just file an affidavit in that regard. We'll see on 21st you did not appear, but if we need further clarification, you may appear through the video conference on that 21st. Okay, if we need further clarification, then you may have. But this is how, why I called you because of this, to explain how it is to be done. Because otherwise, what is happening? I was telling Mr. Mr. Hendrik was telling you, and everything was coming. It is not, means it was not gelling with the earlier stand being taken by your whoever has filed the affidavit. That affidavit is different. Your whatever instructions you were giving were different, completely different. Okay. Mr. So-and-so, the learned the circle officer, Konapur Revenue Circle, is present before the court pursuant to the order, present in person before this court, pursuant to the order dated 5/3/2025, along with certain records. He submitted that as per the map available in the portal, the dark number 5 of pattern number 31 is a thin strip of land. In that regard, this court posed the question to him as to how, and in this regard, this court finds it very pertinent to take note of the latest Jamabondi, bracket the record of rights of Patta number 31. Of village Horutari. In the remarks column, there is a categorical mention that on the basis of an order passed by the ADC, Kamrup Metro, dated 30/12/2004, in case number 68/04-05, the Patta number 6, KP Patta number 6, was partitioned, and on the basis thereof, Patta number 31 came into existence. It would also be seen that at the time of partition, the concerned DAGs, that is DAG number 5, DAG number 44, DAG number 46, DAG number 49, DAG number 50, etc., which were existent in Patta number 6, was brought within the fold of Patta number 31. Taking into account the said aspect, this court inquired with the circle officer who is present in person as to on what basis he had placed an instruction that DAG number 49 had arisen out of DAG number 5. He submitted that he will look into this order, more particularly the order dated 30/12/2004, as well as the revenue records as to how Patta number 5 and Patta number 49 came into existence, was brought within, how DAG number 5 and DAG number 49 came within Patta number 31 and place necessary reports, place the same by way of an affidavit. Taking into account the above, this court fixes this matter on 23rd of April 2025. The affidavit be filed by the circle officer, Unapur Revenue Circle, by 21st of April, on or before 21st of April 2025. The personal appearance of the circle officers, Unapur Revenue Circle, is accordingly dispensed with. We may call you after this, but you have got the understanding how it is to be looked. So you have a look from there, as well as also from the revenue man, because you will get it from Patta number 6 of the earlier member. And then we may ask you after this for going for a demarcation in their where their land is. And thereupon, I think we can proceed. Okay. Also, X, Y, Z to a Y, yes. No, the latest record of rights is kept on record and marked with the letter Z. No, I have dispensed it. He need not appear. You just need to file an affidavit. But on 23rd, if it is necessary, you can appear by 10:30 if you can, on 23rd by video. Okay, video conferencing, he will produce the link. So you will appear out there. If any clarification, then you will get to understand how it is proceeding. And then we can ask you there. He will tell you, he will give you the link. Okay.
One motion, item 1.
Yes, you want to go where? Did you pay that 20,000 or 10,000?
Paid already.
And what is the next date?
It is on 11th of April 2025.
Where's the payment? To notice making it returnable on seventh of May 2025. You file your return statement. I am staying the proceedings, but not to, but that doesn't mean that you would not file your return statement. You file your return statement. Because then only we can proceed. And returnable on 7th of May 2025. Steps be taken upon the respondent by way of registered as well as usual. In addition to that, the petitioner is also directed to take steps through the state related to the registry of this court and file an affidavit of service on or before the next. An application filed under section 24 of the Code of Civil Procedure, whereby the petitioner is seeking transfer of title suit M case number 199 of the 2023 from the Court of the Learned Additional District Judge FTC Punitpur Tejpur to any other court to the Court of the Learned District Judge Nagaon. The reason assigned in the said application, in the instant application, is that the petitioner has no source of income of pursuing the litigation at Tejpur. And she has also an infant, a 2-year-old infant, 2-year-old baby, a 2-year-old infant. And it would be difficult on her part to leave the infant and travel to Tejpur. First, any case filed by you?
One case under DB Act is pending, Lordship. Mean the DB Act case is pending, Lordship. Before
In addition to that, the learned counsel appearing on behalf of the petitioner further stated that a proceedings being DB case number 520 of 2023 is already pending by and between the petitioner and the respondent before the SDJM Nagaon, wherein the respondent herein is duly appearing. Taking into account the grounds shown, this court is of the opinion that this is a fit case for stay of the further proceedings of title suit M, case number 199 of 2023, pending before the Court of the Additional District Judge FTC Punitpur Tejpur till the next date. It is, however, observed and directed that the petitioner shall file the written statement in the said proceedings, which is fixed on 11/4/2025 before the Court of the Learned Additional District Judge FTC Punitpur Tejpur on 11/4/2025 as fixed. The filing of the said affidavit written statement be done by the petitioner through a counsel, and the petitioner need not appear on that date before that.
we have already filed written statement.
Then why is it fixed for
But
written
it
statement?
was not accepted because of non-payment of the cost. But it kindly have a page 24, Lordship.
Then why is it fixed for written statement?
In the order sheet also it was reflected that we have filed.
Okay, hit line to Buseni. Stay there. Stay legal. Stay legal.
Apply.
Attempt two.
Here, what is this? Oh, bad case.
The case where the petitioner passes a land, plot of land from that petitioner passes a plot of land from 88 this.
No, no, no. Why? Why are you before this court?
Before this
Don't
petition,
tell me the story. Why you are coming before the court? You have lot of time. Something has happened as regards the Satpura. You did not appear. You have taken adjournment many times. You have a bad
I have taken it.
Mr. Islam, taken adjournment. Next time when if I get this bench again, I'll dismiss your petition. Take an adjournment today. Mr. S. Islam, the legal counsel submits that the matter may be adjourned today and be listed again, and as he requires some instructions, which are taking into account the above, leave the matter on the 5th of April.
Four.
Discuss on remand order passed by the Honorable Court. Annex of 7, PS 45. Despite without giving any reason, again, I order dated 18/11/54, annex of 8 million. The petition is rejected. Withdrawal with simple, there was no any advantage of the defender's side. Is a government land, when was not made party. So we want to just withdraw the suit.
And what happened? As soon on the other hand, the defendant side by filing the written objections from raise the contention on the ground that since the plaintiff side has the question of issuance of notice under does not arise, whether yes, then
My lord, my sample petition, annexer 4, page 35,
annexure,
annexer 4, page number 35. I filed this petition under order 23 rule 1, radio 51, for withdrawal of the suit. Paragraph 1 may be very important. It appears particularly from the application number 2335 that 79 submitted by the defendant in the above suit that their suit
now what relief you want to seek against the government?
there are no relief.
Then-
That
Then why do you want the withdraw now?
withdraw the
No case. Bad case.
people may be allowed. Simple, I may be allowed to withdraw because the government.
Well, that suit. You can withdraw, there's no, but no liberty. You can withdraw. You want to withdraw, you can very well withdraw. There is no quarrel with that proposition.
Yes.
It is not actually a withdrawal, it's an abandoning of your claim. You want to abandon your claim, you can claim. But if you want liberty,
Do not want to proceed further with this cultural government land because no any prayer made against the government. Other sides challenging that section 154, so it itself is not made favorable. That is why paragraph 1 I have stated.
then
In
you
my,
want just to withdraw the suit without liberty.
although is there, my lord, I pray that if necessary, I may find subsequently if necessary.
Huh?
That encouragement be given.
Then why you are fighting so? You are asking for liberty.
Yes, ma'am.
with liberty to institute a fresh suit.
Actually, I'm not going to file.
So then you should have, I give you, I don't interfere with this order, but however, I grant you the leave that if you want to withdraw the suit with liberty, without liberty, you are always at liberty to do so. The court cannot stop you. That's also the law. But with liberty, the court would not that.
Well, there is also no counterclaim, nothing is there. No benefit of the defendant side. It is a compulsion. Section one fifty.
So you don't want to pursue the suit or you give up your cause of action.
Yes.
That's
is
it.
right.
But why didn't you argue that? This is not your case here. You are making a different case here. Hello. Heard Mr. B. Hussain, the learned counsel, appearing on behalf of the petitioner. This is an application filed and invoking the supervisory jurisdiction of this court, challenging an order dated 18/11/2024, passed in title suit number 30/2019, whereby the learned court of civil judge,
Municip number, civil judge number 2, my lord.
senior division,
Junior,
Junior Division number 2, Kamrup Metro at Guwahati, had rejected the application filed by the petitioner for withdrawal of the suit with liberty to file afresh. First, this court have perused the said order dated 18/11/2024, as well as the application filed under Order 23 Rule 1, seeking withdrawal of the suit with liberty to file a fresh suit. First, this court does not find any ground to interfere with the said order dated 18/11/2024, taking into account that the learned trial court have exercised its jurisdiction in a proper manner. First, Mr. B. Hussain, the learned counsel appearing on behalf of the petitioner, submits that the petitioner would not like to further pursue with the said suit and would abandon the claim in the said suit without liberty. First, taking into account the above, taking into account the provision of Order 23 Rule 11, 11, nah?
one, my lord.
11. Rule 11. The plaintiff would always be at liberty at any time to withdraw the said suit. Full stop. Under such circumstances, it is the opinion of this court that the dismissal of the instant proceedings or even the order being in the above, this court is of the opinion that the order dated that the petitioner herein, who is the plaintiff, in title suit number 30/2019, can always withdraw the said suit without liberty. First, it is observed that taking into account the submissions made by Mr. B. Hussain, the petitioner can file an application before the learned trial court for withdrawal of the suit without liberty. And the learned trial court shall duly consider the same in terms with Order 23, Rule 1, bracket 1 of the court.
Right.
My lord, learned court below allowed me to file, my lord. My last chance, my lord, to file a PW. I am ready to pay twice the cost, my lord.
At
Because
the request of the
dependent
counsel
don't
for
have
the
their-
petitioner, matter sends adjourned to be listed on 4th. I am not going to give this thing.
Admission item 6 and 6 to 8.
To file the affidavit. Nothing remains.
All of the affidavit has come,
So you take that
but,
benefit.
but they have not taken the responsibility.
For-
They say that 135, there is no record to show. How 135 became 130?
That was the report which I have submitted before.
No, no, it's okay, but your plan is, your basic idea is that your application filed under 23 has to be taken. So it will now be taken in terms with this affidavit, which will be a piece of evidence.
So,
In terms with this affidavit, which I will duly put in my order, and you can pursue with 23.
my response assumption would be unless your lordship direct, this 32 and 35 cannot be connected. They are saying, kindly see the affidavit.
Continue.
That is the report lordship. I have this report lordship.
Where is the affidavit?
The same report,
Uh,
lordship has.
Affidavit by respondent number 3 lordship. Filed on 11/3/2025.
11, 12, 3, upon I.
Lordship that yes, 12/3. Paragraph number 3.
12(3), minus paragraph 3.
That answering back to state that on perusal of the draft sheet, so and so, and so are found to be the recorded pattada of dark number so of KP patta number 135 of so. And also on perusal of draft sheet number so of so are found to be the recorded pattada of so. However, no order related to change of patta number so is found in the draft sheet. And as per the field verification done by the circle officer, the petitioner is under possession of the land under dark number so instead of dark number so. It is also been verified that patta number 605 is evolved from patta number 132 and dark number 163 is evolved from the dark number 730 of Siman. It's further observed from the old map of the three dark number 12. But your patta claim for ownership is your landlord is who?
That Shukuna Sheikh and
So Sukuna second year. So they have clarified to that effect.
that is the mere existence of the name of this person in a particular patta, say what could be. I cannot claim that because my claim against this
Mr. Mohanto, we take that order or you see, I have proceeded this matter much beyond the scope of the petition.
Well,
No, Mr. Mohanto, either you take that order which I was giving or I will take up this matter for final.
no, but
decision
I will.
with the prayer which you have.
What I want is.
You have an application filed under 23.
Yes.
Now the 23, it will be taken as whatever you have filed your application will be done on the basis of this affidavit. This affidavit, I brought it only for the purpose that so that it becomes a piece of evidence for you when the matter is being taken up there. So your consideration of your application has to be done in view of all these things. As patta number so and so, as patta number of 574-771-730 of KP patta number 135.
They said 132, they have the linkage. For patta 132, there are linkages, intermediary pattas are there. But for 135, there is nothing. There is nothing. So unless lordship says that now it is their claim, the 135 become 132. So my right will now be proceeded taking it as the 132. Otherwise, I cannot connect it.
No order related to change of so and so to demand is found.
This one.
Now, these 135, how does it and so are found to be recorded pattada of 730 of year. So from this paragraph 3, one can therefore show because this was a land of 5 bighas, 2 kathas or something was given as from the earlier provision. So this land of 135 became 132. It can be seen from this paragraph.
Because there is no such order in the draft sheet, that is
But-
reflected.
There's nothing repaired, but this has become.
Yes, no. that
So I
linkage
can,
be-
on the basis of this paragraph, I can give an understanding of my observation that from this one can therefore say that dark number one, pata number 135 became 132.
Two.
On the basis of this. And
Then
thereupon you may take
according
your
to
action.
that, it can work. Because on record, I cannot connect it.
That was the view of Lordship's earlier on that earlier, the Lordship's.
Yes.
Yes, yes.
So
yeah.
now
That's
that-
why I have been directed to file this evidence.
what
So
it
that
is,
this
certain-
becomes
brought in
this
record.
becomes a piece of evidence for you.
Yes.
Why are there so many petitions?
Well, one is,
Contempt case. We are concerned with 2704 and
2639.
2639. These are the two writ petitions. Same person.
while first one was pending,
Huh?
second, first one was pending, they were thrown out.
They threw you out
Yes. And then we came with the second one. And
And-
that content.
and threw you out for what purpose?
Well, despite the order of this court, they wanted me not to be there. They have some purpose. I don't know, but I have been rather displeased.
But the problem is, you were, they, as per their stand, your possession was in dark number, the government dark, which is the adjacent dark of so-and-so, which is their stand.
These are all adjacent. Boundary was there, so they have, what I understand. Like I was there in my place, but they have converted into 132. Extending where part was taken 135.
No, if the moment it is they are doing that, are they not therefore taking over the land of those people whom the settlement was given?
No, that is,
And that those people are not before the court.
yeah,
Telling.
and
They still say that they have the entire land.
they have no grievance. Otherwise, had it been the case that their case has been, their land has been taken, or acquired, or requisition, it would have been different. It was not that.
So therefore, they should have therefore come before the court. They have not.
Here they are not, but they will definitely come in 23. Notice in 23 petition. Notice will go to them. They will have to, because ultimately they are affected.
No, no, that is 23 is different. I'm
Yeah.
not on 23. I'm saying if, yes, if there was at the time of settlement being done, the resettlement done recently, if they have changed the boundary
Yeah.
of the earlier allotted land of those persons, those two persons, 5 bighas, 2 gatha, those two gentleman and lady, then in that regard, if they have changed it, some portion of theirs would have been taken away. Because you say that you were in possession of their land as a tenant.
Since before, from that time,
No, whatever, you
Yes.
were a tenant of their land.
Yes.
So now, if there's some land has been taken away by them by changing the boundary in the trace maps during the resettlement operation, then their land must have become smaller,
areas should have been,
either smaller or their other portion of the land.
yeah,
Means the 5 bighas 2 gatha remains intact, but it must have the some boundary has stretched to the other side. Something like putting a liquid in a some water in a balloon. So if you put this side, it will go the other side somewhere.
yeah. Otherwise, nothing will see. 132 has been sold, and they are already named, the entire area is there. That is the linkage where upon lordship can direct that this has become 32. Though there is no,
They have also said that.
Yes. they have not definitely said no record, but
Heard
obviously,
Mr. Taken on to the learned senior counsel assisted by Mr. P.K. Bhuya, the learned counsel. Sharma, the learned government advocate, appearing on behalf of the speaker. Petition. By this common order, this court proposes to dispose of both the writ petitions being the petition number 2639 of 2014 and WPC number 2704/2017 as the cause of action in both the petitions are interrelated. And the petitioner happens to be the same. And the petitioner is the same. The case of the petitioner, in brief, is he is a righty occupancy tenant under section 3 (17) and chapter Roman 3 of the Assam Temporarily Settled Areas Tenancy Act 1971, for short the Act of 1971. In respect to a plot of land measuring 3 bighas 2 pathas covered by dark number 574, 771 old /730 new of KP Patta number 135 of Revenue Village, Pachim Boragaon under Moda Jalukbari in the district of Kamruk Metro, Assam. The schedule to the said land. The land has been more specifically described to the schedule to the petition in WPC number 2639/2014. It is the case of the petitioner that the petitioner where riots, the father of the petitioner, late Biren Borgohai, was the original recorded right in respect to the scheduled land since the year 1962. Under the original recorded patada, reads one Ajnu Ali, son of Dhanu Ali, and Kulu Sheikh, son of Amir Ali. On 29/1/2000, the father of the petitioner expired, leaving the petitioner as his sole legal heir. On the basis thereof, the petitioner claimed that she acquired the tenancy by way of inheritance in terms with section 7 of the Act of 1971. The name of the petitioner was also entered in the Khotian, being Khotian number 301, in place of her deceased father, by effecting due correction in the record of rights. The petitioner thereupon also filed an application under section 23(1), read with section 24 of the Act of 1971, for acquiring full ownership right of the scheduled land by way of paying compensation to the patadas as laid down in the Act of 1971. While the said application was pending before the authorities concerned, a notice was issued on 80 under section 18 section, or it is rule 18(2), read with section under section under rule 18(2) of the Assam Land and Revenue Regulation 1886, for short the regulation, stating interior that the petitioner was in occupation of land without authority / sanction as per the report submitted by the Circle Officer, Guwahati Revenue Circle. And the petitioner was asked to vacate forthwith, failing which the petitioner shall be evicted from the land in accordance with law. The petitioner thereupon filed her reply on 27/12/2013, informing the additional deputy commissioner about the existence of her tenancy rights over the scheduled land and submitted copies of the Kotian and the draft sheeter in order to establish her right, title, and interest in respect to the scheduled land. Pus- Upon such reply being shown, the file, the respondent authorities have assured the petitioner, the petitioners averred in the writ petition that the respondent authorities have assured the petitioner upon seeing the reply that no action will be taken. Pus- It is the further case of the petitioner that upon inquiry being made, the petitioner came to learn that the scheduled land was acquired by the government under the Land Ceiling Act without serving any formal notice on the petitioner and her predecessor who have been in occupation of the said land. Pus- The petitioner apprehending that the petitioner's possessions be disturbed on account of the said acquisition and the eviction notice so issued earlier, filed writ petition number 2639/2014, seeking reliefs, seeking various reliefs. The relief sought for were for setting aside the eviction proceedings initiated against the petitioner on the ground that the petitioner was a recorded occupancy tenant of the car right, and further that the respondent authorities should settle the scheduled land in favor of the petitioner in accordance with the provisions of law and in terms with the Assam land policy adopted by the government of Assam in that regard. The petitioner also sought that during the pendency of the petition, no eviction proceedings should be initiated against the petitioner by the respondent number 3 in connection with eviction case number 46/2013. Upon filing of the said petition, it is seen that this court by an order dated 30/5/2014 issued notice and further directed the status quo on the land under Kotian number 301 in possession of the petitioner should be maintained until returnable date. While the said petition was pending, next, while the said petition was pending, the petitioner was evicted from her possession. On 24/3/2017, and resultantly, and being agreed, therefore, filed the second writ petition, being demarcation number 2704/2017, seeking direction not to disturb you were evicted, then why you are asking for that? Seeking various directions, but I would not mention that. Seeking various directions, including a direction that the Deputy Commissioner Kamrup Metro should dispose of the petition filed by the petitioner under section 23(1) of the Act of 1971 within a short span of time. The petitioner also sought for restoration of possession of the land as she was evicted. Upon filing of the second writ petition, this court, by an order dated 12/5/2017, issued notice has the petitioner been evicted or not, Mr. Has the petitioner been evicted or not from the entire land?
Yes, no, they have been evicted. That's because according to us, they were occupying the 704 tag number. That is the government land.
Pursuant to the filing of the writ petitions, it is seen that there has been various numbers of affidavits exchanged. The petitioner filed an additional affidavit on 27th of May 2022, Wherein? Attention was drawn to the spot. That a plot of land at measuring 281.54 R under Revenue Village Pasim Boragaon was allotted for the Judicial Department for Infrastructure Development of the Subordinate Judiciary Assam. By an order dated 10th of October 2013. It was mentioned that the said allottee, however, did not utilize the allotted land within the specific limitation as prescribed by law. And hence the allotment has no longer been existed and automatically stood cancelled and reverted to the government of Assam. It was the further case stated in the said additional affidavit that on 4/1/2021, the Deputy Commissioner Kamrup Metro had passed an order in the tenancy petition filed by the petitioner under Section 23(1) of the Act of 1971. And accordingly, the same have been forwarded to the Revenue and Disaster Management Department for necessary approval. In the said order, so passed by the Deputy Commissioner Kamrup Metro, it was clearly stated that the petitioner was occupying and possessing the dark number 704/1688 new of village Pasim Boragaon, which was originated from old dark number 770/771. It was therefore stated that the respondent authorities have illegally and arbitrarily evicted the petitioner from the same land in spite of a status quo order. It is seen therefore that on 18th of September 2023, an affidavit was filed by the Deputy Commissioner Kamrup Metro, wherein it was mentioned that the writ petitioner had applied to get ownership right over a plot of land at measuring 3 biga 2 katha 0 lecture covered by dark number 704 old 1688 new of KP Pata number 135 bearing Khatian number 301 of village Pasim Boragaon under Jolukbari Moja as per the provision of Rule 16 of the Act of 1971. It was further mentioned that as per the draft sheet of the land measuring 3 bigas 2 kathas, bearing Khatian number 301, covered by dark number 770 old, public 730 new, of KP Pata number 135 in the year 1976, 5/76 was recorded in the name of the petitioner. It was further mentioned that from the report of the Circle Officer Guwahati Revenue Circle, it is seen that the land measuring 802, with the next paragraph, it was categorically mentioned that in the said affidavit, that from the report of the Circle Officer, Guwahati Revenue Circle, the land measuring 802.68 R covered by dark number 704 old 1688 new as recorded reserved land of village Kochingaraga under Jalukbari Moja. It was mentioned that the land from where the petitioner was evicted in the year 2014 was from dark number 704 old oblique 1688 new, originated from dark number 770 oblique 771 of the same village. It was also mentioned that the land measuring 802.68 R under dark number 704 old oblique 1088 new, which is a government land, and the same was already reserved for construction of family court. But inadvertently, it goes out of my knowledge. It went out of the knowledge of the Deputy Commissioner Kamruk Metro. And under a wrong notion, a request was made to the Commissioner and Secretary to the Government of Assam Revenue and Disaster Management Department for correction of dark number 704 old oblique 1688 new from the government land to KP Patta land. It is further seen another affidavit was filed on 30th of September 2023 by the Deputy Commissioner. This affidavit further gives certain clarity in respect to the land from where the petitioner was evicted. In paragraph 3 of the said affidavit, it was mentioned that the petitioner had applied for granting of ownership right over a plot of land, royalty land under Moza Jalukbari village, Kosin Boragaon, having dark number 574 oblique 771 old, oblique 730 new, for a plot of land measuring 3 bighas 2 kata covered by royalty Khatel number 301 against KP Patta number 135. It was mentioned that the petitioner was a riot of Khansur Ali and Sukna Sheikh, who were the landlords of a plot of land at measuring 5 bighas 2 kata 7 lecha under the same dag and patta. After, further to that, it was mentioned that after the completion of the settlement operation, tag number 173 new and Miyadi Patta number 605 bracket new was created from dag number 730 old and Miyadi Patta number 135 old of revenue village Posim Boragam under Jalukbari record, Moza. The said that, as per the revenue records, covers 73.29 hours, which is 5 bighas 2 kata 7 lechas, and was presently under and presently Mohammad Muzamuddin Ahmed, son of Sufana, and Mohammad Sebad Ali and Gul Muhammad, both sons of Khansur Ali, Sayara Khatun, wife of Muzamuddin, and others are the recorded pattas of the said patta. It was also stated that during the field verification, it was found that the petitioner had occupied the land covered by dark number 704 old oblique 1688 new, which is the government land, instead of Rayati Khotian land of dark number 730 old oblique 17363 new. The petitioner herein thereupon submitted reply. Clarifying clarifying that the petitioner have sought for ownership rights under Section 23 of the Act of 1971 from the land of Khaznur Ali and Sukhna Sheikh, who were the petitioner's landlords. On the basis of the above pleadings, this court have heard the learned counsels hearing on behalf of the parties. Upon hearing the learned counsels it appears the following could be desired upon pleadings. This court have heard the learned counsel appearing on behalf of the parties. First, upon perusal of the materials in report and upon hearing the learned counsel appearing on behalf of the parties, it is clear that the petitioner's specific case is that the petitioner's father was a riot of Fajlur Ali and Sukhana Sheikh, and in that respect, a Khatian was issued, being Khatian number 301. The land on which the petitioner had applied for ownership rights under Section 23 of the Act of 1971 is the land admeasuring 3 bighas 2 kathas covered by dag number 771 oblique 574 old and 730 new of KP Pata number 135. Upon hearing, it further transpires that when the matter was heard by this court on 18/11/2024, this court, taking into account the affidavit filed by the respondent number 2, that is the deputy commissioner, dated 30/9/2023, inquired with the revenue department. On the basis of the submissions made by Mr. K.K. Mohanto, the learned senior counsel appearing on behalf of the petitioner, that there was no materials on record which indicates how Patta number 135 became Patta number 605 during the settlement operation. This court therefore directed the revenue department to bring on record the trace map as well as the resettlement operation proceedings in respect to the change in the Patta numbers pursuant to resettlement operations. Subsequent thereto, these materials were placed before the court. On 10/2/2025, when the matter was heard again, on the basis of the documents which were placed by Mr. H. Sharma, the learned common advocate, a question arose. That although from the documents it reveals that Patta number 132 became Patta number 605. But from the documents it could not be seen as to how Patta number 135 became 132. Paragraph number 2 of the order dated 10/2/2025 being relevant for the purpose of the instant dispute is reproduced herein under. On 3/3/2025, when the matter was again heard, Mr. H. Sharma, the learned counsel, appearing on behalf of the district administration, produced an instruction dated 27/2/2025, issued by the Additional District Commissioner, Kamrup Metro, wherein it was mentioned that Patta number 135 became Patta number 132. And the intermediary Patta for old Patta number 132 and new Patta number 605 is Patta number 109. 102. 102. No? It's Patta number 102. Taking into account the said stand on which was reflected in the instructions dated 27/2/2025, and as it has a vital importance in the adjudication of the proceedings of the application filed by the petitioner seeking their ownership rights under the Act of 1971, this court directed the district administration, Kamrup Metro, to file an affidavit in respect to the details mentioned in the instruction dated 27/2/2025. On the basis of the said order passed on 3/3/2025, an affidavit was filed by the Additional Deputy Commissioner, Kamrup Metro, on 12/3/2025. Paragraph 3 of the said affidavit, being relevant, is reproduced herein under. From a perusal of the said affidavit, it therefore transpires. Above quoted portion of the affidavit, it therefore transpires that for perusal of the above quoted portion of the affidavit, it is therefore clear that it is the specific stand of the revenue administration, revenue department of the no, of the district administration, Kamloops Metro, that Ansur Ali and Sukhana say were the recorded patadars of dag number 574/771 old/730 new of KP Patta number 135 of village Pochin Boragaon under Jalukbari Moja. On perusal of the above quoted portion of the affidavit, portion of the affidavit filed by the additional deputy commissioner, Kamloops Metro, the following can be discerned. A. In the draft cheater record of 1957-64 of village Pochin Boragaon under Jalukbari Moja, Ansur Ali and Sukhana Sheikh were found to be recorded patadars of dag number 575/4/771 old 730 new of KP Patta number 135 of village Pochin Boragaon under Jalukbari Moja. B. A perusal of draft sheeter record of 1975-86 of village Pochin Boragaon under Jalukbari Moja, Ansur Ali and Sukhana Sheikh are found to be recorded patadars of dag number 730 of KP Patta number 132. See, although there is no order related to change of KP Patta number 135 to KP Patta number 132, but the logical conclusion one can reach is Patta number 135 became Patta number 132. That is enough for you. See, the petitioner was in possession of land covered by dag number 704 old 1688 new and not dag number 730 old 1763 new of Patta number 132. Patta number 605 is evolved out of old Patta number 132 and dag number 1763 is evolved out of old dag number 730 of village Pochin Boragaon under Moja, Jalukbari Moja. F. The land in dag number 730 old and government dag number 730 old of Patta number 132 and government dag number 704 old are adjacent lands. In view of the said affidavit, and taking into account the limited scope of adjudication on further factual adjudication, this court arrives at the conclusion that the petitioner herein was evicted from the government land bearing dag number 704/0 Code public 1688 new. The claim of, it is further clear from the said affidavits, materials record, that the claim of the petitioner is based upon quotidian number 301, which pertains to that number 730 old 1763 new and covered by patta number 132 old and dark and 605 new of village Pochim Boragaon under Jalubari Moza. Therefore, the question of interference is sought for in WPC number 2639 oblique 2014 by the petitioner against the action of the state is not warranted. This court further observes that taking into account the application filed by the petitioner under section 23 of the Act of 1971, which is still pending, the respondent number 2, that is the Deputy Commissioner Kamrup Metro, shall dispose of the said application at the earliest on the and duly taking into account the observations made as regards the rights of the petitioner of Khatian number which is based upon Khatian number 301 has to be taken into account on the basis of land at measuring 3 bighas 2 katha covered by dark number 730 old 1763 new of and included in patta number 132 old 605 new of Pochim Boragaon under Jalubari Moza. With the above the petitions then.
Not so bad.
At last, Mr. Farmer.
The contempt. Contempt. is emphatic. That is your.
Which
That's
were
not
contemptuous. Taking into account the orders being passed in the accompanying with petitions, wherein this court had held that there was no infraction by the responding authorities, but there was no infraction. Negative. Taking into account the observations who made in the accompanying in the judgment and order passed in the accompanying writ petition, so and so and so and so. And taking and the actions having been taken in respect to dark number 1, what is the government dark? 704 oblique 17 1688 only, and not in dark number so and so A to A kita 763 or A today last 730 old 763 new and which corresponds to Khatian number 301, the question of there being any violation of the order passed by this court does not arise. Accordingly, the instant petition stand dropped.
But today time limit be fixed in that case, huh? But when I said expeditiously, the time limit be fixed. So that
Why
they,
don't you want to come again back to this court?
no, at least they will be the outer limit within the
And
outer,
preferably within 6 months.
so that, I'm like,
But the problem is, all this will go, notice has to go, what has happened, we become prepared.
They have
Well,
to expedite, otherwise they keep on pending, cannot give time to such matters.
that is a very
Another
difficult.
difficult. Apply.
I will make certain corrections here and there because of the fact. Yeah, some petition, in one of the affidavits, you went on a different tangent at all. You went into the question of give me settlement, which goes against you again, because again you are going on the question of Assam fixation. There is no. Anyway, at last, good reasons to long
Yes.
time. But Mr. Monta, you changed the complexion of this matter. Earlier, the council, I would not name it, not be proper. His case, the petitioner would not have got anything. But some change in the complexion happened because of this. At the end of the day, something you get.
True. Apply. Much true.
It's an appeal.
Division.
Vision. An appeal. An appeal.
Intestate appeal. I beg your pardon. Intestate case.
The appeal. So we have to admit the appeal.
Yes. The Lordship is aware of the names and also the dispute. So it
Who are
will come in flash.
Hmm?
Same I am appearing for Froza Rahman and Zana Rahman. They are the
For
against.
that matter.
Yes, ma'am. Your Lordship has been just.
Ah, anyway,
But this is about successful certificate which has not been granted in 12 years.
but you see, it's an appeal.
Yes.
The appellate court gets the jurisdiction as per me when we admit the appeal. Don't you think so? When we admit the appeal only, we get the jurisdiction,
Yes.
not that by issuing a notice. In fact, should have been appealed, appeal should have been admitted then.
So I'll make a submission Your Honor,
Yes.
for admitting.
No, it's the first time it has come.
Okay, yes. Sorry.
Is your case so bad?
Oh. It will come as a flash, my lord, within 5 minutes. Your Lordship has heard me. Okay.
Heard Mr. So-and-so, the limit counsel appearing on behalf of the appellant. Is an appeal filed under section 384 of the Indian Succession Act 1925, challenging the judgment and order dated 21/6/2024, passed in succession certificate case number 136/2013. Taking into account the grounds of objection taken grounds of objection.
Yes.
Have you made it so big? Huh? Taking into account the grounds of objection taken,
On page 31.
the appeal is admitted. Between judgment or order passed by dated so and so, passed by so and so, so and so. Succession case number. Appeal is admitted, call for the reports. Steps be taken by way of registered as well as usual. What?
A date may be fixed.
How? First, the steps have to be complete. Records have to come.
It's only the-
You've taken steps, very good, you have taken steps, but the thing is,
direction.
don't take steps when a notice is issued.
Yes.
You know, you have to. Why don't you do one thing? I can do one thing. I can fix a date by giving you ability to effect service by Dusty.
I'll do.
Again, with the steps be taken by way of steps. Is the matter again on 2nd of June 2025.
It's a Tuesday. Other than Monday, if it is on Tuesday, if possible,
Wednesday,
schedule permits.
Wednesday,
How Wednesday?
on 4th of June 2025.
Item 10.
Public Vivo. The appellant herein is given the liberty to take steps by way of justice, with it through the registry of this court and file an affidavit of service.
Yes. So good.
To Milai River.
10.
Yes, what is this?
My lord, here in this case, my lord, we are challenging the impugned order, lord, fine, at page 55. My lord, in the MSC case, my lord, the petitioners are claimant, they want to re-examine the PW2 to ascertain, my lord, to clarify the vagueness in the evidence as regard the employment and duty assigned on that day.
When did you ask for re-examination?
My lord, first petition was filed on 35/2023. It was not taken up. Then second petition, my lord, at page 44. It was
Here is
filed
the
on
record reveals the claimant has filed
7/8/20.
petition number so and so stating that deceased was carrying golden iman on the date of, but the said fact has not been placed before the court by way of evidence, right? And hence the play free to allow the claimant to call the manager of so and so to prove the above fact. Court also reveals that during the pendency of the aforesaid petition, it was filed when?
My lord, first petition on 35/2023.
In the meantime, the evidence of DW 1, 2, 3 all are over.
My lord, now all cross-examination part is remaining. Cross-examination part of DW2 is remaining. DW2 is, my lord, cross-examination DW2 is pending.
And who is this manager of Swagat?
My lord, he is the deceased is employee of that, Swagat. My lord. Swagat
This is to prove
private-
what?
My lord,
This is to prove what?
my lord, as I got the, my lord, his duty assigned on that day and for what purpose he was in the vehicle on that day.
Why is it necessary?
My lord, it's necessary because according to the claimant, my lord, he was he was in the vehicle in connection with duty. Some materials are to.
So they have taken the plea of gratuitous passenger.
Yes, madam. That
So
plea has been
therefore you
taken.
want.
Yes, madam.
But did you reserve your right to give evidence earlier?
My lord, that part is missing, my lord.
And?
For my lord, ends of justice, my lord, limited purpose of
Ends of
clarification.
justice.
I'm appearing for my lord 1 and 3, my lord. Like
You are for what? Owner.
owner and the driver,
What about this thing? Who? Which two?
the insurance.
Your insurance company. What is it? Let us see the claim petition once.
My lord, claim petition, lord, you will
Faithful
find-
date of so and so,
Date of
and the
78,
victim so and so was coming from Constitution to his house, sitting inside the vehicle, bearing registration, the driver of the drove.
That my lord, he is harping upon that, as he wants to put certain questions as regard to his service. If I may take my lord to page number 19. Detail number 4. He himself writes is that he is a service holder. Then my lord, the cross examination of whom he wants to re-examine, it's at page number 39.
Yes.
My lord, I would like to highlight the date as well, my lord. It was done on 23rd November 2020.
And in the third, second line, my lord, I am working as a manager in Swagat, which is located at Doha Bora Road, Jorhat. The next line, my lord, this was a furniture technician under Godrej Interior, and his monthly salary was so and so.
So the manager was already there.
Okay. He was examined, he was cross-examined, my lord, and after 3 years, he come up with his application. The first application, my lord.
2020, my lord, already PW is examined, my lord. And at the time of the DW2, my lord, it is to know that one of the point not examined. That's why, my lord, there on the Lekuna, they have filed this petition. And 2020, on the
Then, my lord, little below, my lord, Exhibit 7 starts from Exhibit 7. Is this certificate issued from our firm in support of the fact that the deceased Harilal Hiralal was an employee of Swagat EB Road. So, my lord, if my lord peruses the petition which he has filed, page number 43, 40, next 6. The second paragraph, my lord, after the perusal of the record, it is found that one of the vital information regarding the employment of the deceased, that is already there, my lord, employment of the deceased.
Only that part clarification is required, my lord, whether he was on official duty. He was in the vehicle, whether there is a connection of the official duty or not.
No, did you
That
say
part.
did you say in your claim petition that thing?
The claim petition has.
Claim petition did not say a single word about that you were traveling on that. You say you were sitting in the vehicle of so-and-so, the driver and driver rationale. You did not say anything that you were in area of work. You did not say anything.
That is there, my lord.
And
That-
you take, have you
that's-
taken that plea out there?
provided
Let us
in
see,
statement.
without previously it is submitted that OP number Iman was driving the vehicle and the said driver was coming towards Swansea cruising Iman. Taken to submit. No negligence on the part of the employee. Where is it being said that you are gratuitous passenger
In their,
in the written
in their
statement?
written of, my lord, in their objection petition, that part is there.
Huh?
Their objection petition.
No, in the written statement,
Yes, my lord, their written objection.
written statement.
Written objection, they have not.
Why, forget about the written objection. Written objection does not come into the scene unless it is there.
My lord. Yes, their written statement is at least 29.
In your evidence on chief, did you say that?
My lord, evidence is, my lord, that has not been mentioned.
Then how do you bring in something which is not there for the first time? Nowhere it is being mentioned. Now you want to bring this. No. First of all, in your evidence in chief, did you mention that he was going on this truck on as a worker?
He
That
was,
is not there.
he was a service holder of the company,
Where is it?
my lord. That claim petition itself mentioned, my lord.
No. Petition
He's a
now.
service
no.
holder.
Service holder I am not. That I am the claimant number 1 and claiming compensation on the date of so and so due to traffic accident so and so and sitting in so and so reached the way Iman as a result of which we are after the accident my husband was taken to hospital and so died. I am deposing today on the strength of Iman. I am working as a manager of Swagat, which is located Doha so and so. This was a furniture technician under Godrej Internal and his monthly salary was 12,000. He used to draw amount of so and so. He was working for 22 years. He died and motivated as a salary statement. Exhibit 3.1 is the signature of the owner of the said firm. I have access to all, I have not submitted anything. Now, if you say that he had gone under employment, then what happens?
My lord, they are plea, my lord, that they have a gracious passenger that will not.
No. His gratuitous passenger will come in. Is the vehicle belonging to the company?
No.
Then
Is hired,
who hired?
my lord. That
Who-
part is required, my lord.
No, who hired it?
That company hired or he was given, my lord, to board in that vehicle. Hired for
There is not a single whisper anywhere. It is not the company's vehicle. There is no mention that it has
Hired
been hired.
for-
You are saying it, you won't do it. You should have said in your evidence, you have not. And this is not even your application. Secondly, if he is a gratuitous passenger, if it is any other vehicle you are going out there, you have to prove the hire. Where is it? Anywhere it is being said that this vehicle was put on hire.
but that has not been mentioned.
Then-
That clarification is
Who
required.
will give it? How can he give it?
My lord, employer will clarify.
Maybe if you are there, go to under the Employees Compensation Act. He died on the accident because of that, whatever may be. Yes. Therefore,
Then
heard
that
Mr.
opinion
A.R.
will be
Sigdar, the
given by-
Limit Council appearing on behalf of Mr. N.M. Nampadino, 1 and 3 and so appearing. An application filed under Article 227 of the Constitution challenging an order dated 31/5/2024 passed in MSC case number 1628 of 2016, wherein the applications filed by the petitioner bearing petition number 2912 of 2020 23 and petition number 1268 of 24 were rejected. So, this court had duly perused the materials on the court, including the claim petition, the evidence on affidavit of the claimant witness number 1, the evidence of the claimant witness number 2, as well as the application so filed by the petitioner and the application so filed by the petitioner, which were registered as petition number 912 of 2023 and 1268 of 2024. From a perusal of the materials on record, it is transpired that the evidence of the plaintiff, of the claimant, from the materials on record, it transpires that nowhere it has been mentioned in nowhere in the evidence in the claim petition as well as in the evidence so adduced, it has been mentioned that the deceased was traveling on the vehicle which met with the accident. While he was in employment. The evidence of PW1, CW2, PW2 was completed on 23rd of November 2020. Thereupon, the evidence of BW1 and BW3 was also duly completed. Examination in chief of BW2 was given and the suit and the proceedings was pending at the stage of cross-examination of the DW2. When both these applications were filed This court have duly taken note of the order passed by the learned member MACT 1 Kamruk Metro Guwahati and the reasons assigned for rejection of both the applications. Upon perusal thereof, this court is of the opinion that the learned tribunal MACT number 1 Kamruk Metro Guwahati did not commit any error in exercise of its jurisdiction. Consequently, this court does not find this fit case to exercise the jurisdiction under Article 227 of the Constitution. The interim order passed by this court on 19/7/2024 stands vacated, and the parties herein who are duly represented are directed to appear before the learned trial court, before the learned court of the MACT number 1 Kamruk Metro at Guwahati on 19th of May 2025 for further proceedings of the same claim proceedings.
Right.
Item 11. Lordship, the petitioner is the plaintiff of the suit. My lord, I have filed a money suit paying for recovery of 2,50,000 from the defendant, my lord, respondent. Then notice were issued, my lord, notice was issued. Then, my lord, the respondent, my lord, defendant, he received the notice issued from the, my lord, civil judge division. Hereafter, my lord may kindly turn to page 22.
Page
22.
Oh, what is this petition? What are you challenging here?
My lord, judgment was passed ex parte, my lord. My lord, here, my lord may kindly see, my lord, page.
So the delay has been condoned
delay has been condoned.
and you are challenging here.
Yes.
Why?
My lord, they have preferred a, my lord, order 9 June 13 petition, my lord, praying for setting aside the ex parte decree, my lord. And along with that, my lord, they have filed a, my lord, delay application petition, and I am now, my lord, challenging the delay condonation order, my lord, by way of which, my lord, delay was condoned. Delay was of, my lord, 1 year, 4 months, 15 days. Here, my lord, my lord, the statement, my lord, is made, my lord, by the respondent, my lord, in the delay condonation application. My lord, this is the incorrect statement. They are blaming upon the advocate, my lord. Whereas, my lord, in the record, my lord, there is no engagement of any advocate. My lord, on 20, my lord, 27/10/2021 in the money suit, my lord, the defendant, my lord, received the notice, my lord. Then, my lord, on 2nd of November 2021, my lord, the one advocate, my lord, filed a petition, my lord, page 23, third paragraph, my lord. Therefore, the petitioner prayed before this honorable court to adjourn today's proceeding and fix another date for the same. And the wakalatnama will be furnished on the next date fixed. Thereafter, my lord, on the very next date, my lord, no wakalatnama file, my lord, no representation, my lord. My lord, page 25, defendant side is absent without state. So now, my lord, they are blaming, my lord, their advocate, my lord. Engaged advocate. Whereas in record, my lord, there is no engaged advocate, my lord. There is no wakalatnama, no engaged advocate. And another aspect, my lord, the defendant, my lord, though in his petition, my lord, mentioned the address of Golaghat, my lord, he has contended that, my lord, he is doing business at Nagaland. But regarding doing any business at Nagaland, he has not explained, my lord, submit any documents regarding his business at Dimapur, Nagaland. Another point, my lord, the delay.
The counsel come to the point. Don't beat around the bush. You're not concerned with that. What is your point of argument should be? Here, what is order 9 rule 13? Here the section 5 application was allowed.
Yes.
Order 9 rule 13 was allowed.
Order 9 rule 13 was still pending.
He should set aside the ex parte decree and here is admitted for hearing. Mails. So section 9 was, this was delay was only condoned.
Delay was condoned. But my lord, may kindly see, my
You
lord, when
object
my
to
lord,
that,
there
do
is,
one thing. You won't touch this order. Let this order be there, but the learned trial court shall take in, decide order 9 rule 13 without being influenced by this order of law 9-7. The only one. Perhaps. Therefore, heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, and Mr. So-and-so appearing on behalf of the respondent. An application filed under article by invoking the supervisory jurisdiction under Article 227 of the Constitution, challenging the order dated 9/7/2024, passed in the case number 132 of the 2023, whereby the application under Section 5 of the Limitation Act 1963, condoning the delay in filing the application for setting aside the ex parte decree, for filing the application for setting aside the decree, ex parte decree dated 2/8/2022 was allowed. This court had perused the application under Section 5 of the Limitation Act 1963 filed by the respondent herein, wherein it is being mentioned that after service of summons, the petitioner, the respondent herein had consulted with his advocate, one Dikankar Herman, for taking necessary steps in that behalf. And the counsel thereafter did not inform what further steps were required to be taken, and also did not take any steps in the said suit. Because it was only in the month of October 2023, the respondent herein had come to learn about the passing of the ex parte decree, and immediately thereupon filed the application on 15th of December 2023. It is seen that the respondent herein, the petitioner herein had filed objection stating inter alia, filed objection to the application under Section 5. Stating inter alia that the petition so filed under Section 5 was not supported by necessary documentary evidence sufficient to establish the cause of delay in preparing the accompanying petition. It was also mentioned that the petitioner, the respondent herein was also negligent, and as such, there was no sufficient cause for condoning the delay under Section 5. It was also denied that the petitioner is a businessman who was doing business in the state of Nagaland during the period. Admitted as it may, the learned trial court, by the order dated impugned order dated 9/7/2024, had condoned the delay of 1 year, 4 months, 15 days in preparing the application to set aside the ex parte order dated 1/8/2022. Judgment and decree dated 1/8/2022. In doing so, the learned trial court had assigned reasons which, in the opinion of the learned trial court, constituted a sufficient cause within the meaning of Section 5 of the Limitation Act. The exercise of discretion so conferred the exercise of discretion by the learned trial court in a matter pertaining to condonation of delay normally is not required to be interfered with unless the said order suffers from perversity, unreasonableness, irrational, as well as beyond the settled principles of law for condoning the delay. The learned trial court came to an opinion, was of the opinion that the petitioner had explained the delay that due to his business engagement in Nagaland and the advice received from the engaged counsel, he was unaware of the necessity to appear personally in the suit. The learned trial court also came to an opinion that upon discovering the ex parte decree, the petitioner took steps to address the matter. On the basis thereof, the learned trial court have condoned the delay. In the opinion of this court, the delay, the condonation of delay could not, the impugned order by which the delay was condoned does not call for any interference in exercise of the supervisory jurisdiction of the court. On the ground that the scope of jurisdiction under Article 2 to 7 of the Constitution is limited. Further to that, this court is also not sitting as an appellate court. Considering the above, this court is not inclined to interfere with the impugned order dated 9/7/2024, whereby the delay was condoned. Next. Before, however, this court further takes note of that by an order dated 5/8/2024, the further proceedings of case number 132 of the 2023 arising out of money suit number 23 of the 2021 was stayed in view of the above order, whereby this court is not inclined to entertain the instant petition for the reasons above stated. The interim order stands vacated, and the parties are directed to appear before the learned trial court, that is the court of so and so, in the junior division number 1, Golaghat, on 19th of May 2025. For further proceedings of case number 132 of the 2003, arising out of money suit number 23 of the 2021. Yes. Before parting with the record, this court, however, finds it relevant to observe that the learned trial court, while passing the order, while deciding the application for setting aside the ex parte decree, judgment and decree, shall bear in mind that there are two grounds on which an application, such an application is maintainable. First, when the summons have not been duly served. And secondly, when the defendant was stopped on due to sufficient cause from appearing in the suit when the suit was called on for hearing. The fact that the petitioner, the respondent herein, who is the defendant, have received the summons is not an issue. Therefore, the question which would have to be decided by the learned trial court is as to whether the respondent herein oblique the defendant could not appear before the trial court on the date fixed for hearing on account of sufficient cause. The learned trial court shall also bear in mind while deciding that it shall not be influenced by the order dated 9/7/2024, whereby the delay was condoned, as well the present proceedings by which the order dated 9/7/2024 has not been interfered. The learned trial court shall therefore decide the said application on its own merit and pass appropriate orders by giving due reasons.
Item 35, at 2 p.m.
Filed against the order dated 14/8/2024, Annexure 6, whereby the petition filed by the petitioner for accepting the WS to the counterclaim has been rejected. And WS has admittedly filed belatedly. WS to the counterclaim has been filed belatedly, along with a petition to accept the same. That was rejected by the impaired. the grounds that there is no sufficient cause shown in the petition for accepting the document.
Applicant. You're challenging which order?
14/8/2024, page 110. Annexes.
What is wrong?
Basically, there is no wrong in the order. But what happened, Lordship, the WS and counterclaim filed on 16/11/2023, the late hour. The counsel for the petitioner is totally unaware about filing. Counsel for the plaintiff was unaware about filing of the WS and counterclaim on 16/11/2023. On next date also, counsel for the plaintiff has not received the copy from the court. That was received on 24/1/2024. So
22-1.
24/1/2024.
Then how did the counsel for the 22-1/2000?
Receive on 24/1/2024.
Okay. Now, how did the council come to know the next date for filing of the fix for the suit?
Uh,
How did he appear on the next date?
Next date, he just filed the Hazira and he has not checked.
No. How did he come to know the next date?
He could serve. He could serve.
So it was not written out there for WS against counterclaim. Then, right?
But admittedly, Lordship, that was received on 24/1/2024. This is a suit for partition
So what?
in between the family members.
Okay, 1 lakh cost.
Lordship, sufficient time was given to them.
1 lakh cost.
Four people.
And then
The
no.
counsel who is conducting before the court as a pro bono, he is doing the case.
Heard Mr. S. Dekar, the learned counsel appearing on behalf of the petitioner, Mr. Answer appears on behalf of the respondents. First, this is an application filed under Article 227 of the Constitution challenging the order dated 14/8/2024, whereby the learned trial court had rejected an application filed for accepting the written statement against the counterclaim. It is seen from the materials on record that on 16/11/2023, the defendants had filed a written statement cum counterclaim, and the suit was fixed on 16/12/2023 for written statement against the counterclaim. It is seen. The materials on record further show that on 16/12/2023, as well as on 24/1/2024, the counsel appearing on behalf of the plaintiff did not receive the written statement cum counterclaim. And there was a specific direction issued by the learned trial court for receiving the written statement cum counterclaim. And the learned trial court had also fixed specifically in those two orders for filing of the written statement cum counterclaim. On 26/2/2024, the counsel for the plaintiff stated that due to requirement of some documents, the written statement cum counterclaim could not be filed. The learned trial court, taking into account the above, fixed the matter on 4/3/2024 for filing of the written statement. Even on 4/3/2024, the plaintiff did not file the written statement for which a cost of rupees 1,000 was imposed, thereby fixing 11/3/2024 for filing of the written statement cum counterclaim. Thereupon, on 11/3/2024, as the plaintiff even did not file the written statement, the learned trial court had passed an order rejecting for proceeding with the suit, thereby rejecting the prayer for adjournment for filing of the written statement. The counsel appeared, the plaintiff thereupon did not take any steps against the order dated 11/3/2024 and further participated in the said suit. It is seen that on 25/4/2024, the plaintiff filed a petition seeking further time for filing draft issues and list of documents. The above therefore shows that the plaintiff had, by way of waiver, had given up his right for filing the written statement cum counterclaim. It was only on 14/6/2024 that the plaintiff filed the written statement cum counterclaim along with the petition number 2636/2024, praying to accept the written statement against the counterclaim. First, this petition was rejected by an order dated 14/8/2024, assigning good reasons by the learned trial court. First, taking into account the limited scope under Article 2 to 7 of the Constitution and the reasons so assigned by the learned trial court in passing the order dated 14/8/2024, this court finds no ground to exercise the supervisory jurisdiction under Article 2 to 7 of the Constitution. Consequently, the instant proceeding stands dismissed. Further to that, taking into account that the order dated 2010/11/2024, the further proceedings of title suit number 60/2023 with state is hereby vacated, and the parties who are duly represented are directed to appear before the learned trial court on 5th of May 2025 for further proceedings of title suit number so and so.
Some cost also. That is already on.
I asked you 1 lakh.
Unless the land is a 1.5.
So what? Can't help it. You cannot take this court for a drive. You have not taken, if you are not vigilant, have you taken any action against that council? Well, if you had a land negative. It is also seen that the petitioner who is the plaintiff had also not taken any action against the concerned advocate for his negligence. For these reasons, this court does not find any good ground for it.
52.
Order of last CRP.
The I was called for in the morning, but it is not on record. So Lordship may kindly take up the matter at some time.
This is only for cross-examination of PW1 and 2.
Then from that date, PW was started.
From
From the appearance, then also 17/8, because I have annexed the order which is challenged also.
2015.
Then thereafter 2017, if this order of CRP is.
No, that I understand. I've seen this. That is why I'm saying this is only for PW1.
Then PW started from after dismissal of this case. Because on that day, the case was.
Understood the DW started, but see the manner in which the trial court had proceeded. I've seen the order sheet. That is why I'm saying.
Order sheet.
There,
Corona, it was okay, my lord. They are not appearing. They are taking time. All are there. It is not that they have vigilance to filing the.
Finally, see here, the PO is transferred till 2018, 20. Then Delia is not there, PO transferred.
It is sometime PO was there.
And as per notification, 2020 it is closed, 2020 it is closed, 21 it is for DW. This is not yet in a special, this suit is not a special case, hence the suit is adjourned next date. This is how 21 this has happened for DW. Defendant heard, learned counsel represent the case before defendant side is absent without steps. Perusal of the CR reveals the instant suit is pending for the state from Iman. Hence, one last opportunity is given. There is no contact with the defendant or cognitive hands. Long time, hence court notice may be sent to the defendant. This is being written. And after that, what has happened from 2021 onwards?
Then thereafter also Corona started. Corona for that period it has they are filing.
No, thereafter
Not fine.
there is no other order. Where is the other orders?
Other orders, if required, my lord, I'll bring because it was
Then-
applied.
That
Even
is
then,
why when I saw this, you have I saw this something, you don't.
till 25, they have not filed, my lord. This is my service. Till 24, from 17 to 24, they have not filed the evidence, my lord.
How many witnesses you have? Only one?
Only one way. Only one.
He has filed the evidence on affidavit.
Yes, Lord. This,
So once the evidence in affidavit has been filed, you cross-examine, bring your witness on that day, cross-examine, matter over.
Some court,
Of course, how much?
has
You have engaged the senior counsel, obviously, then your client has good money. You will put it at 2 lakhs. 2 lakhs. How much? Or is it because of the fear your senior has not come out here to reduce the cost? Oh yeah, we see the senior here.
Yes.
So taking your stature, Mr. Doctor, we put the impose a cost of rupees 2 lakhs. If she was appearing, it would have been 15,000, but you are appearing to make it 2 lakhs.
one date, my lord.
One day.
Fixed date, on that day, I explained.
They have already paid 10,000.
10,000 is peanuts
For adjournment.
for 17,000 from 2017 onwards. For a written statement, I was putting 1 lakh. And now for evidence, it is 2 lakhs. And when you are appearing, otherwise, what will people think? We engage a lawyer who takes a fees of 3 lakhs, and now for 2 lakhs, he doesn't get the cost. It's too cheap of matter. How much?
This person somehow he paid 10,000.
Somehow he didn't pay 10,000. We have delayed the proceedings for another 10,000. That is another cost.
But this cost which has been deposited before this honorable court, it may be reimbursed to the legal service.
Why not directed that? Directed that. The cost of rupees 10,000. Where's the IA? IA has not come.
Surprisingly, when I
What is
mentioned this
wrong?
morning,
You must have some defect out there.
no, there's no defect at all.
Who are the parties? You have the name of the parties?
Vinit Kumar De and Vidhan.
Sir, kindly give it to me.
Srimati Vinita De,
Give it to me from your application. I এখন লিস্ট হয়েছে না ইয়া হয়েছে না 896 না IA is 896
8 names.
লাই লোগো দেখ is an application filed in the spirit of Order 41 Rule 20 of the Code of Civil Procedure and Order 1 no or in the spirit of Order 41 Rule 20 read with Order 1 Rule 10(2) of the Code of Civil Procedure 1908 to strike out the names of the respondent numbers 4 and 5 in the incident accompanying petition and to insert the names of Srimati Vinita De. What about 4 and 5?
Four, my lord, he has no legal heir.
No legal. Strike out the name of the respondent numbers 4 and 5 and to insert the name of the of Srimati Vinita De and Sri Binit Kumar De.
Visit,
Binit,
visit.
Bijit Kumar De. The legal representatives of the respondent number 5 herein who were already impleaded were substituted before the learned trial court in title suit number 02/2024. Post. Taking into account the above, this court allows the instant application by striking out the name of the respondent numbers 4 and 5 and inserting the names of and including Srimati Vinita De and Sri Bijit De. As respondent number 4 and 5. First, a fresh memo of parties be filed by the counsel appearing on behalf of the petitioner during the course of the day. First, I extends allowed. First,
My lord, title suit number 95 of 2005.
2005. No, earlier it was. Now it is 2024.
What? Yes, 95 of 2005.
Are you sure?
This is the earlier number TS 95 of 2005.
Now what is the number? It's
Now-
2 of 2024. Isn't it?
Now,
Oh, now.
Now I think TS 2 of 2024.
Where's the impugn order?
that is review petition he has filed.
Plaint reflects, my lord, page 24, TS 95 of 2005.
On 95. 95
95 of 2005.
95 of 2005. Mr. Doctor, how can a court help you? So many mistakes in this petition. So here 1 lakh is the cost and another 10,000 for another cost out here upon your junior counsel. Senior counsel it not be proper to impose the cost because he did own draft. Sure. List this matter again on 28th of March 2025. You file that now.
So, 20th March, my lord, I'll be out of station. Any other day?
Stay order vacated. We'll have it on 4th of March, April 2025.
Let it be there, somebody else will appear.
No. Stay order vacated. I'm not extending this. Next.
Dated item 39.
এটাই অর্ডার দিব না লিস্ট দ্য ম্যাটার অন হিয়ার আই কোনো থেকে অর্ডার দিব আই মেন কোনো দিব এত কোম্পানি লিস্ট দ্য ম্যাটার 4th of May April 2000
39.
yes what is this oh both of them out there
Yes,
only.
my lord. Yes, my lord.
Lord, I'm sorry, I could have come, but there was a partial matter in Shillong and I was doing on VC.
No, it's
Ultimately,
okay. It's
matter
okay.
also got adjourned. I'm sorry.
Mr. I have a principle out here. I don't grant adjournment on senior counsel. However, if the senior counsel has some difficulties on his own, it is a different thing. If he says so. Otherwise, I don't.
had difficulty, my lord. I could not.
But not on the ground of a senior counsel, I don't grant.
No, we'll take care. Next time it won't be done. It will not be.
Tell me, what do you have to say, Mr. Datta?
Yeah, my lord. My lord, we have already placed the agreement to sale before this honorable court. On the last day of the order of this honorable court has noted down also. I'm only on some additional points. On some additional point, my lord. We have filed our, as per direction of this honorable court, we have filed the additional affidavit, the annexing the copy of the compromise decree and the mutation order.
Oh, you have filed that? Where is it?
Yes, my lord. Lordship will find at page number 126.
Big one. Big one.
Oh, this one.
Yes.
What is this copy of the compromise decree?
Yes, Lordship will find page 126 is starts. We have translated the copy because in the Calcutta High Court, all handwritten, my lord. So we have to translate it. Lordship is the relevant part is the relevant point to be noted, my lord, that the plaintiff hearing is also a part of this compromise decree. The plaintiff in the suit is the respondent hearing. He is also party to that compromise decree. So he is aware of the terms of the compromise decree. Then, my lord, the second important point to be noted, I'm respectful submission is that the lot C is allotted to the defendants, principal defendants and the pro forma defendants, as your lordship is already been heard on this matter. Now, Lord C kindly, my lord has kindly have a look at page number 181, my lord. It starts from 181 is schedule 4. Schedule 4 is Shillong Potti Silchar. The lordship kindly turn to the next page. Lordship will find that for the purpose of partition, said schedule number 4 proposed to divide / make partition by 3 lots as lot A, lot B, and lot C. Now, lot C is allotted to the principal defendants and the pro forma defendants, my lord. Now, there is a condition, my lord, in lot C. Lordship, kindly have a look at lot C. Lordship will find it at page 184.
Yes.
It starts lot C. May I read, my lord?
Jointly to Pranab Bhuya,
Yes.
defendant 12B, son of so-and-so, Lavanya Bhuya, 15B, so-and-so, so-and-so, so-and-so.
Aforesaid, all the parties shall own said lot C jointly, undivided proportionate share. Now, the last part, this is the very, very important, my lord. It is to be cleared. Lordship has got it. It is to be cleared, the said lot shall not be parted or partitioned further.
Now, you see, so there is no further partition required.
Yes, so therefore, there's the 40%, 60%, whatever the share they have distributed, it was decided that if you sell jointly to be sell, and the share has to be proportionately divided. If you develop the same, then the construction so developed that can be proportionately be divided.
Dispose of, develop the said allotment.
Yes.
Now, why do you say that it has to be done jointly?
Because Lordship will find here that the terms of the compromise is they agreed to accept the jointly in accordance with above mentioned share and shall dispose, sell, or develop the said lot. Receivable consideration, area as consideration shall be distributed. This is the entire land amongst the parties according to the proportionate share mentioned here in above. So whatever the share, the partition, this 20%, 40%, etc. And it is to be cleared that the said lot, that is the lot C, shall not be parted or partitioned further. So there is a prohibition clause. The parties are bound to sell or dispose of, develop the said
So
allotment.
therefore, as per your agreement, you were not required to partition.
Yes, my lord. So entire land.
So you
The
were
ent-
required to acquire.
Yes, my lord. And my lord, the pro forma defendant has already filed their written statement, as informed by the learned counsel on record at Silchar, my lord. May I request my junior counsel, my lord, my assisting counsel, to please the written statement, because it is on the record of Silchar case. Both the parties have got it. So in that written statement,
Don't have any instruction on it.
No, Mr. But both of you are in video.
Yes.
You are placing a matter here. How do you electronically give it to Mr. Mishra?
I do not know whether the.
Or are you
probably-
saying that we should not give you the opportunity of video conferencing link? If you want to bring something, he also has a right to know.
My lord, I understand, my lord. But I'm in assumption on that
So the very good thing is I escaped myself from dealing with this matter for the time being.
Lordship, my humble request is my lord has disposed it.
I can't now because if you want to rely upon a particular document.
No, I'm not relying. No, my lord,
because that was one of the basic idea in passing that order as to what is the stand of the. I made it very clear out here in my order that as to whether.
May I request one thing, my lord?
No, please.
My lord. May I request one thing? Because I may make a request only, my lord, for the consideration of this honorable court. My lord may fix the matter tomorrow, day after tomorrow. Meanwhile,
no, Mr. Doctor, that is not possible tomorrow or day after, because if I have to dispose it of, it is very difficult and sign. I won't.
Then may I place my second request, my lord?
Again, another request. Tell me.
Yes. Then matter may be fixed on 22nd or 23rd of April, my lord. We are not hearing because they have already get the benefit of the this injunction order. We cannot dispose it, my lord. So if there is difficulties tomorrow, day after tomorrow, my lord.
And taking into account the deed of agreement, which is the subject matter of litigation, categorically mentions about the compromise. The mutation of the land records fixes this matter on behalf of further consideration.
That mutation order we have filed, my lord.
The fact pertaining to the compromise decree as we has been put into the agreement, the behavior they are directed to be money.
That mutation order also, that all their names are jointly in the records that we have filed.
No, therefore,
my
your agreement, one thing was clear, that what is required for you is to acquire the 40%.
Absolutely correct, my lord. I cannot, because these terms of the compromise is missed out from my submission also in earlier. I'm very thankful, my lord, that this matter, this compromise decree is now on the record. Now, while I going through this compromise decree, my lord, that there is a prohibition. We cannot make it 40 or 60. You have to jointly go for either to sell the entire and then divided the proportionate share. So the pro forma defendant must be a party to this all arrangement and agreement, my lord. That is the whole difficulties. And this compromise decree being aware by the this vendor and the vendee, both of them, they are the parties to the compromise decree.
Anyways, okay. So Mr. An additional affidavit has been filed by the appellant pursuant to the order dated 13/3/2025. It has been also brought to the attention of this court that that a pro forma defendant numbers 567.
My 5, 6, and 8. 7 has
5,
not
6,
filed.
and
He
8
is
have
residing in
already
Calcutta.
filed their written statement before the learned trial court. Taking into account that the affidavit was filed, taking into account various submissions have been made on the basis of the said compromise decree, that the said land in question cannot be alienated without the pro forma defendants being a party to the agreement. This court would like to hear Mr. D.K. Mishra, the learned senior counsel, on this. So, however, taking into account that this compromise decree was brought on record by filing an affidavit only on 28th of March 2025. And also a reliance is sought to be done on the basis of a written statement of the pro forma defendant numbers 5, 6, and 8, this court fixes this matter again on 23rd of April 2025. 22nd, no, 29th,
29th, I have a difficulty. 23rd or 24th, my lord, any day.
24th is not possible.
23rd, my lord, kindly.
23rd, if I take it now, you see, a lot of lawyers are waiting out here.
22nd,
And
my
Mr.
lord.
Mishra doesn't come to the court except on hearing day. To understand.
I know, I am very grateful, my lord. I'm 20, either 22nd, 23rd, or 24th.
Yes, Mr. Mishra, when it will be convenient for you?
My lord may take it up on 30th.
30th is April. 30th of April is the one.
Yes.
Is it okay,
Yes.
30th?
My lord, my lord. I'm because the senior counsel has.
April 2025 at 2 p.m.
My lord. Grateful, my lord. I will brought this, my lord, by an additional affidavit. This.
Not necessarily a copy of the said written statement filed by the pro forma defendant number 5, 6, and 8, which is sought to be relied by the appellant, be served upon the counsel assisting the Mr. D.K. Mishra, the learned senior counsel.
My lord. Yeah. Grateful.
Yes.
12. What it is?
It's now debarred filing written statement.
What?
Written statement is not allowed.
Submits that as well as in that regard that by way of an additional affidavit brought on record as a medical affidavit with their person. It's not submit that. Okay.
Because her illness, he could not able to come to the court for filing written statement. On the very days he went out for previous medical checkup. 39 onward, the medical document.
What is the matter about suit about?
It is for specific performance of this contract.
Where's your written statement? Have you filed it?
I have not yet filed, but written statement is ready in my file. It is, in fact, it was ready on that day also, but he could not even come due to her illness.
Lordship, on 13/8/24, Your Lordship, when no application was filed for it. And my letter submitting that the WC is ready for filing. Before that benefiting, whether he filed before the trial court immediate thereafter, or before Your Lordship, that it is ready for Your Lordship. Without any application, without any adjournment, Your Lordship, they remain absent on 13/8/24.
Your medical test certificate.
Because there, Your Lordship, but the submission that WC is ready.
Mr. Jha, many submissions are being made. Whether the submissions affect the court is a different thing. I allowed this, I issued the notice. I don't issue the notice also in these type of cases. They had the pain of filing lot of claims. You see, when the matter was moved before this court, first day, he did not get any money. Second date, he did not appear. Third, I said nothing. Fourth, then he filed an affidavit. Fifth, then he. This is not going to help you. You have filed a suit for specific procurement. Let him file it. 25,000 cost. Suit for what? You have taken the money from him. Had paid to 60,000, 75,000. You got a lot of money. 6,41,000 you have already got. Then you can spare some money. Pay that.
25,000 is fine.
That will be considered to be the interest. Eh?
It was her illness, so she could not claim. Can we consider?
Okay, we do one thing. We put a lakh of cost. You don't need to pay. But if you lose the case, he need not pay that lakh. Okay. You have a lakh rupees to get. He says that he is going to pay. So this 1 lakh is already being paid to you. Okay, done. 25,000. Because you have not been. Why didn't you file it thereafter immediately? One has to be strict. If I don't be strict, every time a person will come. Oh, do one thing. If the court has, high court, the trial court has rejected, let me go and get it in the high court and get a 5,000 rupees cost. Better off. Type of things won't work. See, Mr. Jha has appeared for how many days? He has spoiled so much of money of the plaintiff. Heard Mr. So the learned counsel appearing on behalf of the petitioner, Mr. N. Jha appearing on behalf of the respondent. The petitioner is aggrieved by the order dated 13/8/2025. 24, by which the petitioner was debarred from filing the written statement on the ground that the statutory period of 90 days was over. This court have duly taken note of that from the material, duly taken note of from the materials of record that on 16/5/2024, the summons were duly served upon the petitioner, who is the defendant, in title suit number 184/2024. The report in the court of the civil judge senior division passed by the order dated so and so. On the same date, the defendant appeared and filed the petition for the purpose of filing the written statement. The then trial court allowed the said application and thereby fixed 22/7/2024 for filing of the written statement. The defendant thereupon also did not file the written statement and sought for time. And accordingly, court fixed the matter on 13/8/2024. On that day also, the defendant did not file any written statement, and it is under such circumstances the impugned order was passed. This court have duly taken note of that pursuant thereto, the defendant did not take any steps for filing an application for recalling of the order before the learned trial court. Dated 13/8/2025 for and permitting the petitioner and defendant to file their written statement. And it is only on 16/12/2024 filed the instant proceedings. This would it is also relevant to take note of that when the matter was taken up by this court, an additional affidavit was filed to the effect that the defendant was under treatment from 22/7/2024 to 13/8/2024. The said grounds were assigned in the opinion of this court could come within the ground within the purview of exceptional circumstances to permit the defendant to file the written statement, more so when the learned counsel appearing on behalf of the defendant categorically submits that the written statement is ready and can be filed on any day as this court may direct. Be it as it may, there has been certain laches and negligence on the part of the defendant. And if no cost is being imposed, it would show, no cost is imposed, it would not be in the interest of administration of justice. Consequently, this court interferes with the order dated 13/8/2024 passed by the learned trial court insofar as debarring the plaintiff, the defendant to file the the petitioner from filing the written statement. This court fixes the matter before the learned this court. Vacates the order, interim order, dated 28/2/2025, passed in title suit, whereby, by this court, whereby title suit number 184/2024 was stayed, and directs both the parties who are duly represented to appear before the learned trial court on 23rd of April 2025.
Second April, the date was already fixed on 2nd April. You may appear
On 2nd of April 2025, on which date the defendant shall file his written statement without fail. It is further observed that this court imposes a cost of rupees 15,000 upon the defendant, which shall also be deposited before the learned trial court. It is observed that the deposit of the amount of rupees 15,000 shall be a condition precedent for acceptance of the written statement. The plaintiff would be at liberty to file application before the learned trial court for release of the said amount, and the learned trial court shall pass a petition.
13.
Yes, what is this?
Right, please, your lordship. This matter, your lordship, was basically we are challenging direction of the order, not allowing child go through process of your lordship. Basically, I think,
Why do you say that the DNA is the only evidence which can be there? There is no other sufficient.
first and foremost, this child was born to the wife of the patient. They were separated, but then she died. subsequently the child was with the parents of the wife. And then the child was given, these are the allegations by the petition, given to the other, I think,
No, I remember your allegation.
then,
I
then
remember
they
the allegation
changed
that,
the name of the child.
that the grandparents,
Yes,
the
they changed the name of the
grandparents
child and
have
say it's not my child.
taken your child. And they say that this is a different child. This has nothing to do with you.
You know, that's a separate person, name separate. The different name has been given to the child. Another date of birth come up, birth certificates come up, which has a little bit of a different
Did
different
you
date
file a
of birth.
police case? That where is the child?
No, at least your lordship. since
No. You
guardianship
see,
act
no,
is there.
Mr. Counsel, first of all, see the recent judgment of the Supreme Court in EV and Rathiram or something categorically observes out there that
Which
the
case?
power to exercise the
Vivian
power
Rathiram.
of
Vivian Rathiram. Yes, I have got that judgment.
saying that the power to exercise the DNA testing is there,
Yes.
but it is dependent on two circumstances. First, there has to be no sufficient evidence by which the court can draw a conclusion that the paternity can be tested by any other means. The second is after the satisfaction of the first. The second is what would be the impact upon the child if this test is given? Now, is there any other evidence?
In that case, your lordship, basically, I think the issue was legitimacy of the child. That Rathiram case, which I have gone through the judgment.
So what
There
is
was a-
difference?
Here,
There the principles are being laid down.
yes, it has been laid down. It says what is
Taking into account the judgment of Puthuswamy, the principles are being culled out and taken. And as such, this is being given that when you can go for DNA testing first, you have to make out that there is under no circumstances there is any other evidence by which you can be satisfied. That whether the paternity of the year. The second is after that you have to find out.
Now the question here in this particular case, how am I supposed to know when that there is a particular date of birth, name change, whatever it is, the mother is not there. It is difficult for the person to petition to show in how that particular child is not his child or that is his child. Or they can say, he can also say, both are saying the same thing, that this is their child and he says it is his child. So I don't know where from it can be found because the mother is not there at
And
this
you have to
moment of
think-
time.
You have to think where can it be?
That
It is
why
not for
not
this court to suggest it.
This paternity test in this case would have revealed it is not a big deal.
No, you don't go for the paternity test on the first day itself. You have to come up that there is no other, this is the requirement,
fine.
that there is no other evidence which can be dealt with. If there is insufficiency of evidence, then only you can do it.
Exactly. The question is because initially
Have
we
you-
have given the
Have you seen into other angle?
no, their WSC or lordship. It comes after their W. Because
No.
we have said that this is the date of birth, this is the child, this is such.
So what evidence you have?
They came up
No,
saying,
what
"No, no, no,
evidence? As of now, have you given any evidence?
evidence is the, your lordship, the birth certificate.
No, have you given evidence in the court?
No, court evidence is not yet.
Then how is it possible? Unless you give evidence, the court, on the basis of the evidence, has to come to a satisfaction. Then only you can file that application.
Now they have filed, the court has actually.
You have filed the application premature. In that line, the wording, I think paragraph number 46 or
I-
47.
The lordship is correct. It says that should be the last resort, basically.
And I have also delivered one judgment. What is the number? I'll give it to you. That was a case of also DNA. Where the mother was, where the defendant, but this is a different thing. There I went into another aspect also, bringing into effect Article 20 also, because here what was happening, the defendant has filed a counterclaim saying that the plaintiff is not the son of so and so. So apart from that, there was no evidence left. So they couldn't have filed that at that point of time by the counterclaimant that you go for a paternity. What was rejected, it was lightly rejected for different reasons. But another aspect comes in those type of cases, that are you going to allow the plaintiff to give evidence against himself? Because you can't give that. Although 23 says that 25 says to that effect that in respect to an offense, but same principle also applies there. That is it. Okay. So you see my judgment on that point. In fact, when you did this matter on 29-1, the judgment in Ivan Rathinam came on 28, isn't it?
Judgment of Rathina, that was 28th of January.
28. Think about it, what to do. It is the only way out. You have to adduce evidence, then you need to file it. And so therefore, what you require is, you may pick the leave for this court. May not be disposing of today, but seek the leave of the court so that you can go ahead and file an application afresh when after the evidence is. This is the only way out.
I'll take it.
Mr. U.Y.S. Mananda, learning counsel, appearing on behalf of the petitioner, seeks sometime in certain instructions. List the matter when do you want? When? Before Bihu, after Bihu, after Puja, after holiday, when do you want?
Yes, but if possible, immediately after Bihu.
List the matter on 23rd of April 2020.
Much. 14.
Yes.
Come for orders, Lordship. There is a delay convention, but that is not correct, Lordship.
Condemnation application, I think.
892 and 893 of 2025.
But there is, they don't, this is Raju Ali.
Yes, Lordship.
Huh? Are you sure?
Yes, Lordship, I filed it.
It is said to be within time. Raju Ali.
Calculation is
Huh? Application case number
60 days,
107.
it is taken as 90 days.
Huh?
It has been taken as 90 days.
Ah.
The MFA is 60 days. The 17/12/2024, 60 days expire on 15/2/2024. I have filed it
You got the order when?
on
When
the
did you get this order?
17/12/2024.
Huh?
The date of judgment is 17/12/2024.
Then when did you get it?
Lordship, that's not correctly because in WC, they
The
just
copy is
sign it.
immediately given.
They just sign it without giving that date wise.
Then how do you calculate the period?
That's the date of judgment. Because it's not possible to know this the date is the judgment. Like in MS, it is that column wise date when certified copy applied for, when date fixed for stamp, that is not given. Sign on the same day, they are taking your mistake. I think the mistake was, it was presumed to be 90 days,
And how much is your delay as per you?
23 days. I have filed analogous case.
How much?
23 days.
3 days.
23.
Then how to do it? It has been held to be within time. It is 60 days. To the High Court or 90 days? They have taken it as 90 days.
MFA is 60 days also.
Huh?
It's the MFA.
MFA is 60 days or 90 days. To the High Court, all that.
It's 60 days also. For worksman company, employees are 60 days.
Is it mentioned anywhere? Or limitation account? Where is it? Appeal to the High Court is 90 days.
Days, Lordship. Section 30, subsection 2. A period of remedy for appeal under this section shall be 60 days.
Listen. Because I have to pass that order, na? Section 30.
Section 30 subsection 2.
This court have duly taken note of. Order Shikhan. This court have duly taken note of. Section 30 bracket 2 of the Employees Compensation Act 1923, which stipulates the period of limitation for an appeal under section 30 to be 60 days. Mr. Arusami, the learned counsel appearing on behalf of the appellant insurance company submits that in that view of the matter, an application was filed for condonation of delay. It is, however, seen from the office note that the limitation has been taken as 90 days. In that view of the matter is, the registry is directed to place it before the filing section for appropriate correction and remedial action.
Statutory appeal, Lordship.
Railway,
Lordship.
okay, appeal admit call for the records steps. Appeal admit call, you call until everybody. Is an appeal filed under so and so, appeal admitted, call for the records, steps upon the respondent by registered as well. Stores versus Dealer Corporation. Mr. God, what is this? What are you challenging?
I'm telling you, order dated 19/7/20.
Huh?
19/7/25/24.
19/7/24. What order is that?
By this order, plaint was directed to be returned to the plaintiff for filing in appropriate court.
Plaint was returned
Hello.
in view of jurisdiction. That could come on the return of the plaint. Then why are you filing an FAO?
Court, my lord, order 40.
Plaint returned under order 7/10. And whatever the limitation, delay condone.
My lord, actually, it has been due to some defect which has been listed later on. It was filed within time.
So what is your ground on which you are
Well,
saying
my
that it is
lord,
within time?
in fact, my lord, this clause was, my lord, in a letter, my lord. It was a letter dated 13/6/1986, my lord. And this letter, my lord, was agreed to be effective within, my lord, 31st December 1986, my lord. So my first ground is, my lord, that first, this letter is not a valid agreement, my lord. Secondly, my lord, even if assume, my lord, that this letter is an agreement, my lord, even then this letter was, the validity of this letter was, my lord, expired on 31st December 1986, my lord. So the transaction thereafter, my lord, are not covered by this letter, my lord.
Why?
My lord. And secondly, my lord, my claim is not based on this consignment. My lord, by this letter, my lord, I was appointed consignee agent, my lord. Now, my lord, my claim is not only for consignee agent, my lord. There are some other transactions also.
What is this? There is another order.
Yes, my lord, this is second time.
Second time rejected.
My lord, earlier it was in my favor, my lord. Then they approached the honorable, this honorable court directed the trial court to hear the parties and pass a appropriate reference. Then I have,
Cross-examination is done.
no, my lord. Evidence is filed, my lord, cross is not, because in the meantime, the further proceeding was stayed by the Supreme Court. For cross, my lord, initially, my lord,
Appeal admitted, call for the records. Steps be taken by way of registered reporting living. Like.
My appeal was dismissed, Lordship, for default. I have filed an application under order 51 rule 19. That is also dismissed. Here, order is at page 19.
How much was the delay? How much was the delay?
So, Lordship, it was dismissed on 26. Five nine 2024. An application was filed 23/9/24.
How many dates you did not appear?
Only two occasions, on that day and.
5-9, appellant absent without steps. Two consecutive appeals.
Two occasions.
Therefore, admitting this appeal, the appeal is admitted. There is an appeal filed against order.
Twenty-six 11/2000.
43 rule 1T. Code of Civil Procedure. Challenging 26/11/2000. Of the civil judge, senior division, 24 at page 15, with the first appeal court in title appeal number 10 of the 2022 had rejected the application under 19 of the code on civil procedure 1928, named for readmission of the appeal, which was dismissed for default on 5/9/2024. The appeal is admitted. Steps be taken upon the respondent by way of registered as well as usual in the course of the day to serve. Appeal is directed to the list. There is no requirement for calling for courts. The appeal is directed to be listed on 7th of May 2025. It is the appellant is further directed to effect service by way of custody rooted to the ratio of the spot and file an appeal. Because otherwise, if I admit the appeal and it goes
Yes,
to
Lordship, it will go.
come up after 10 years.
Your Lordship.
Yes, what are you challenging?
Challenging the order of the DRT, my lord. That is my
Huh?
in page 12 for refusing to allow file additional documents.
8/1/2025 on. 8/1/2025. What documents you want to bring?
Documents list I have given, my lord. Two documents. Earlier, my lord, already I have some out of 20 documents, my lord. 8 will be new. And my lord, is into the application, my lord. That is page 19, my lord. Earlier not in possession of the option passage. And documents and everything, etc.
Yes, tell me, why these documents are required?
Proper adjudication of the matter, these documents, the land documents which are not in possession, earlier in possession of the.
Now, what application did you file?
Beg your pardon.
What application did you file? No. How did you become a party in that proceeding?
Auction passenger.
So you were an auction purchaser. You filed your written statement and you did not enclose these documents.
That's out of here, my lord, two documents I had submitted earlier.
No. These are the documents you did not bring in.
That was not at that time. Later on, he got the certificate copy from the circle office and other office, land documents. I have stated in my application. The application page 18, my lord. The respondent 5 has also paid the bill amount as per option. of
So this
50.
land was sold to you
I have purchased on my lord option.
and they have filed a section 17 proceedings.
Yes,
This is under the Surface Act.
that's it. Yes, sir.
Yes,
Sir, you have filed a 17 proceedings.
yes, yes, same, you know. Actually, what had happened? There is a particular doc 756. I am the owner, madam. That is not the mortgage property. And not on the garb of purchasing the auction property, they want to grab this land also. That is how, my lord, alleging collusion between the bank and them, my lord, we filed it. Then, my lord, we filed the essay. Essay is in progress. But lordship, should kindly come to two paragraphs of the order dated 8/1/2005,
Yes.
at page number 13. If you lordship should kindly come to the third sub-parameter.
It is
It is observed that the particular respondent 5 is the option purchaser and he has filed the instant IA seeking to bring on record 20 new documents in surface proceeding. It is observed from the record that pursuant to the order dated 3/10/19 and 7/1/2020 of this tribunal, report of Advocate Commissioner as well as Circle Officer Azhara Deputy Circle has been filed. The same report of the Advocate Commissioner as well as Circle Officer Azhara Circle have not been challenged by the petitioner till date. No justification, reason, or explanation have been provided by the petitioner as to how the said documents are relevant to the issue forming the subject matter of the essay. However, no justification or explanation have been provided by the petitioner as to why documents which are now being sought to be brought on record have not been provided earlier. The final hearing of the essay number 1607 of 2019 commenced on 16th of August 24 and hearing was done on various dates.
The petitioner has no locus standi to comment upon genuineness and validity of the said deed number so and so in respect of that number 756 because the petitioner is not a party to the sorry said deed. The petitioner has assailed the report of the advocate commissioner and the circle officer on the basis of allegation that the registered sale deed being deed number so and so is forged and fabricated document. The tribunal has no jurisdiction to entertain, try and determine any allegation of fraud, forgery or connivance. Any challenge to the ownership of the SRPC applicant in respect of that number can only be cited by competent court of civil jurisdiction. Under the provisions of SRPC Act, it is mentioned that the auction purchaser has right to obtain possession in respect of property, receive marketable claim compensation and redressal, but have no right to interfere between borrower and the secured creditor and to file additional document. The secured creditor or the bank has the right to file additional document regarding property, and it is for the bank to remove the difficulties before selling out the property to auction. Bank is bound to remove such obstacles. So this is the view, my lord. How these are relevant, why it has been introduced, nothing has been indicated. And the sale deed in respect of tag number 756, even if they dispute it, they have to do it only by before the competent civil court.
But since the
There is absolutely no dispute that between the national highway and the DAG number 802, which is the DAG in question, my lord, there is a DAG of 756.
So here the petitioner was sold 802.
Yes.
Now why you are wanting to challenge 756?
DAG number, and my land, DAG number, there is no land and separate DAG number. That's try to establish this fact, they have to file this document.
But wouldn't that come within the civil court?
Civil court depend proceedings going on, that will be disposed of
Which one?
before the day before it. The tribunal, my lord.
No, no, but whatever you
Proceedings going
say that 802,
Actually, the bank should have.
756 is different land which is different from 802, and 802 contains a land of 4 Katha 16 lecha, 2
Yes.
bighas 4 Katha 16 lechas which we have purchased. And 756 does not come within it. Now, you came into existence only on 1/10/2019. And the sale deed was done in the year 2007 of 756. How can you challenge the sale deed here?
Same deed, I am not challenging either. Because.
Then
they
why
have
do
the
you
bank
require
is
these
the-
documents?
Bank is the right authority because the land, my lord, mortgage, my lord, land mortgage the bank.
No, no,
But
you are
then-
saying that they have produced a fabricated forged and fabricated sale deed.
Yes.
Now, merely saying it would not do it. You have to prove it. You can't prove it before the debt recovery tribunal in that aspect. You
That
need
is
to
right,
file a
but
suit.
Because it's a separate thing, my lord, one proceeding is pending because I have purchased, it is related to debt recovery tribunal. No, nothing to do with the civil court. So, my lord, unless they establish, my lord, by giving the proper documents, so, my lord, they may go later on, my lord, to the civil court. But at this stage, while the proceeding is going on, they will be deprived. So at least they should be able to file the documents so that they can argue. Otherwise, they will be left behind.
So why didn't you file these documents at the initial?
That was not in their position, my lord.
Why?
Because it is often later on they have come to know that often when the circle office and
So where is your statement made in your petition?
but it is there in their petition before the
Where?
tribunal, my lord.
Para 7.
That after issuance of
That you
this
came to
circle-
know about these documents later on.
Yes.
When? On 21st of
Like
October
every-
2024.
being light is that in order to bring light upon the fraud which is being played by the borrower
before the honorable tribunal and to bring in to the justice hereby which the truth of the forged and fabricated shall be conversation so by way of which the borrower is.
Now, do you have the originals of these documents?
Beg your pardon?
Do you have these originals of these documents?
So which-
Photocopy would not do there. You have the originals of these documents. How do you prove it tomorrow? Why do you need these?
That will be called, my lord, that is, my lord, it is there, they have submitted, my lord, a copy of the documents, but my lord, later on during the hearing, it will be submitted. It will be submitted, my lord, original documents with the authority.
And any action that has been taken against your property?
As on date,
Huh?
so they want to take, now as on date, they have not been able to, yes,
They've stopped it.
yes. But if your lordship kindly comes to page 18, paragraph 4 of their application. But basically, this is their step. How is it maintainable before a debt recovery tribunal? That after the issuance of sale certificate of the secured asset in favor of respondent number 5, the borrower is creating a mischief by clandestinely producing a forged and fabricated sale deed dated so and so, whereby portraying the same to be an interloper property which is allegedly hypothetically being in existence exactly on the same place where the secured asset is also located, hence whereby very cleverly creating a melodrama with the connivance of the government officials, by way of which borrower is trying to dispute the measurement, topography, etc. Bona fidely purchased by auction purchaser, that is respondent number. Well,
Since the issue
the
is there,
subject of the mortgage property is covered by 802. Nobody is disputing that. Now you want to also input land covered by 756. That is the whole difficulty.
since my lord, my limited power is to my lord, they direct since my lord, katana of cases.
Why the bank is not helping you?
Up till now, because the proceeding is going on, it will end, my lord, so.
No,
I'll be hand-
see, the main protection is to be given by the bank.
Exactly.
You are the beneficiary.
Bank.
What has
not-
happened to the bank? Who is the
Bank
paying?
is not
Yes,
moving.
bank, why you are not helping her?
Bank is not moving.
That's the case. After in the course of proceeding going on before the they got themselves completed. Option one. Now the one of protection is that 80 rupees monthly regard. 756 came out later. Why? Oh, that's 756. Out of the cost of that. For the bracket one. Now, 802, between 802 and the national highway, there is a small portion of land. The borrowers are claiming that is the part of 756. We have also that portion is not covered under the
Means 756 is across the road. And then you have a road, and then you have
portion of land, unmarked land. And it's road. Now, when they have deposited the liability for the bank, for creation of individual mortgage, this specifically stated that the urban country, not 802, national. That is there. No dispute was raised and taken from record. There was no dispute. The borrower remained silent at all. Came up
only after surface application was part of it. Now subsequently, the bank had filed original application also for recovery the house and due of the bond.
No. Who was the owner of 802? And who is the owner of 756?
Yes.
So now they say that some part of stone of 756 falls on this side. Now what does the revenue map say?
And so they are also purchase are facing, they are being records of different things. The borrowers have also got out
What are you doing? You have sold it to her.
what it is.
No, understood, but you have to protect the interest of her. What are you doing? And why you are not bringing these documents there?
But these documents are not with us. But the documents are not with us. Because at the time of creation of mortgage, 30 was deposited.
How are you saying that this document is not there? Kindly see the application at page 20. Serial number 9. Copy of the trace map of dark number submitted at the time of when the loan sanction was granted. How do you say that that document is? That is 802.
We have submitted.
It's the council. Why you are not seeing number 9? Page 20. Serial number 9. This document has to be with you.
This may be that business that they have submitted. At the time of creation of mortgage, we have provided. So with the record, with the record that we are.
Now, why number 10 you are not giving it?
Number 10 is not with us.
Not with you, but anyway, when you are protecting yourself, have you called for this? Because you have to protect the interest. You merely you have to pay, they have paid the money to you. When you are the owner, you have exercised your right under the SURFACE, you are also to be responsible to protect the interest of the auction purchaser. What are you doing?
So far, it's still concerned. We have produced all relevant documents. That has been deposited to us. There is no doubt about it, and there is no. So for 756, it was not never more than stuff. So naturally, no documents will be, and we have shown this part of line is zero. All relevant documents is with the year. And these placements I have come later on during the course of year. They have produced one, the purchaser has produced one. It's a question.
Now, what does the circle officer say? You got a report from them. There's a report being given out there. That is being mentioned in the order. The council, have you read that order?
125.
We read that order properly. Kindly see page 13. Down below, report of the advocate commissioner as also the circle officer Azra Revenue have been filed. Are you saying the circle officer has not done it?
No, the circle officer.
Kindly see page 13. You have not read that order. What about the circle officer? The order makes it very clear that there is a report. Kindly look it out here. Report of the advocate commissioner as also of the circle officer. Azra Abdullah to the of the advocate commissioner. The said report of the advocate as well as the circle officer have not been challenged. Kindly look into page 13.
The advocate commissioner's report we have checked.
What about the circle officer?
Because I down.
So are you saying that this order is wrong? No, if the circle officer has reached You have to understand that the petitioner out here is a beneficiary, is not a beneficiary, he has purchased from you with trust that you are giving a good property. Okay. Now, if you don't prove it, you are the burden is on you. You cannot say that I have sold it, then I'm not, I wash my hands, I don't have any business out there.
So far, we have, from before we have filed separate challenging and pending. Entire camp. Circle officer was
So the dispute arises in the case as to whether 756 is this way or that. That's the issue. Isn't that?
Yes, ma'am.
Why do you
Yes,
need the
sir.
other
Yeah.
documents?
It-
Why do you need the other documents?
My lord. this-
No, Mr. Madam, kindly see, why do you require this prism noise, all these
Problem is
other
that, my
documents of RTI road, no land under national highway and all? Why do you require the size of the land as per draft Sita? That he can very well give it.
This put is only one thing, my lord. In place of 802, the circle officer they are showing that it is 756, not 802. So there is no land of 802.
So therefore, why haven't you submitted to find an objection?
802.
Why you are not filing an objection before the trial, before the DRT?
DRT.
Is it for this court to suggest or give you advice?
No, my lord.
Then,
My lord, the
and
documents,
it is
that's
your duty also.
documents, this
The auction purchaser may not know, the counsel for the auction purchaser may not know. But are you not there to protect the interest of the auction purchaser? So have you, not necessary, but whether the auction sales certificate which you have given, which contains 2 bigger 4/6 lessons, is there or not? Does the revenue map show that land or not? Does it show so much of land or not? That is the issue. I'm only on that issue. Does here, because their stand is 756 comes this way. So therefore it's 756 subsumes 802. So it is for you to prove, not otherwise. And they got a circle officer's report and the advocate commissioner's report. And you have not challenged it.
filing evidence. Either mortgage, the documents were submitted to us. It is 802, and we have created mortgage on the basis of the title deed and the confirmation, placement and other documents submitted by the borrower. Mortgage is submitted. We have provided all the documents. Both the options.
Have they filed objection? Mr. Chaudhary, you have filed objection to this application?
Actually, essay is ours, essay is there. But essay has been filed by us.
No,
Where should we first-
Against
No
this
objection
application.
in this way. I think it has been filed, that's why the court dealt with it, Miller, tribunal. From the order, it is
Ah,
evident.
it is there.
It is
It is
there.
there. Why have you not enclosed all these things in here?
Objection petition.
Yes. How do this court decide?
Filed by an additional affidavit.
I am not satisfied.
Actually, the dispute is between the bank and the landlord, and if the documents are allowed to be,
Madam, I am
Yes.
not here to help you out.
my lord.
If you don't help yourself,
where
I
you'll
can't
go?
help you out.
If the tribunal has declined to accept the documents, then where he will go?
It is seen that the objections which were filed before the DRT have not been brought on record. And the petitioner have only enclosed the application as well as the interim order. From the above, nothing can be discerned as to what actually is the dispute. Concerning the above is the matter of the truths.
I may be allowed to withdraw and my lord file a press. Debate will be given in that press. Because my lord, otherwise the case is a good one. Because the additional documents normally. out of-
Case is good one means you are to therefore come up in a proper manner. You have to put the thing on the bank. Why you are not
Let-
talking with the bank and
Let me
asking the
go
bank?
and file a press. Liberty may be can be given to file a press. Otherwise, but for petty things, why should I?
Then so here the
Suffer money.
counsel appearing on behalf of the petitioner that she has instruction for the instant petition. However, taking into account that there are various documents which ought to have been included along with the petition have not been. So taking into account. Then it's closed on the file. Liberty, however, is given to file a petition and closing the documents, all the documents which have led to the passing of the
All right, 20.
Please, your lordship, my lord,
amendment.
step was taken notices to this have much information, my lord. Was just with the prayer for.
Your order, this was the amendment which should have been allowed.
Amendment.
No? These are subsequent events.
Subsequent years, your lordship also taken the view that I will consider it. Next that other thing.
The petitioner to keep over the instance should be made. When were you, when was the suit fixed for, the evidence?
Well, evidence also, only evidence affidavit filed on 27/7/23.
Huh?
Case was fixed on 28, but his cross-examination not started, my lord.
No, it's okay, but when was the, when was the evidence started?
Evidence started from, well, actually 27/7/2023. Because, 3, 4,
And when were you dispossessed?
this was just, my lord, on 24/4/23. Only 5 months, 15 days only.
24/4.
24/4/23, my lord. This was it. Cross-examination not started, just, I am the plaintiff, my lord. I file evidence
Have
affidavit.
the other side filed objection? No.
Not fine. They are not contesting, my lord. Notice is already served, my lord. Then in the civil suit, they have filed the WS contesting, but they are taking time for cross-examination, or repeated dates. Cross-examination not started. Just we filed the PWs of plaintiffs, my lord.
So now you want to insert
Prayer portion, the recovery of poison, my lord.
only recovery of possession, no?
Yes, my
Nothing more than that.
No, other is not there.
Only this. Okay. Or Mr. B. Hussain, the learned counsel appearing on behalf.
हाँ बोलिए मेंशन करेगा
An application filed.
हाँ ठीक है
challenging
हाँ
under
हाँ एकदम
the constitution.
एकदम
Very often, who is there? Yes, who is there on the line? Yes, it's so. Who is? This is an application filed under Article 7 of the Constitution. Thereby, as by the learned court of the civil judge Junior Division Vanaiga in midday case number 110/2023. Thereby, application filed 6/17 was rejected. This court had perused the application filed under Order 6 weeks. And it is seen that from the said application plaintiff was dispossessed from the Schedule B land, na?
Yes, sir. PS 42, my lord.
From the Schedule B land
PS
on
40.
24/4/2023. And the defendants have forcefully occupied the suit land. It is under such circumstances the said application was filed seeking amendment of the claim insofar as insertion of the belief, insertion of a paragraph in the claim that the plaintiff were dispossessed on 24/4/2020 in B land and for insertion, that is paragraph 15A, and for insertion of a prayer and for substitution of a prayer of prayer B, that is for recovery of cast possession instead of confirmation of possession. It is seen that the learned trial court have rejected the said application on the ground that this application was filed after 4 months, after 6 months from the date of dispossession, alleged dispossession. That too, when the suit has been fixed for cross-examination of the plaintiff witness. It was therefore stated, this was therefore observed by the learned trial court, that there was no diligence, due diligence on the part of the plaintiff in seeking amendment of the plaintiff. This court have heard the learned counsel appearing on behalf of the petitioner. None has appeared on behalf of the petitioner of the plaintiff, and none has appeared on behalf of the defendant or the respondent in spite of service being meted out. It is seen that the amendment which is being sought for is in respect to subsequent events which took place pursuant to filing of the suit. And in fact, even after the filing of the, after framing of the issue, isn't it?
Yes, my lord.
It is no longer, it is well settled that with the framing of the issues, the trial is set to begin. Therefore, in the opinion of this court, the amendments so sought for strictly will come within the purview of the proviso to order 6 to 17 of the code. Inasmuch as these subsequent events occurred pursuant to the trial having already begun. There had been also This court also takes notice that if this amendment is not allowed, the plaintiff would have to again file another suit, which would lead to multiplicity of suit proceedings. Additionally, with the statements being made on affidavit in the amendment application that the plaintiff have already been dispossessed, the plaintiff cannot get the confirmation, cannot get the consequential relief which was originally there in the suit, which would affect the plaintiff's right to claim a declaration in view of the proviso to section 34 of the Specific Relief Act. Considering these above, this court is of the opinion that the learned trial court ought to have allowed the amendment of the plaint as sought for, thereby to insert paragraph 15A and to substitute the relief B. Considering the above, this court interferes with the order dated 11/7/2024 passed in Ms. case number 110/2023 and allows Ms. case number 110/2023 and allows the amendment application that is Ms. case number 110/2023. This court further takes note of that by an order dated 17/2/2025, the further proceedings of title suit number 8/2022 pending before the court of the learned civil judge junior division Bongaigaon was stayed. The stay order is vacated and the petitioner herein, who is the different plaintiff, is directed to file the amended claim on or before 10th of April, 11th of April 2025. On 11th of April 2025. It is observed that if the amended claim is not filed on or before 11th of April 2025, the consequences under order 6 rule C 18 would ensue. Yes, no more disposal from today. Now.
21.
Out of the
This is an appeal lordship under the LV Act.
you want what?
Pay and recovery given, but not as per Nanjappan. That is our contention.
Huh?
Pay and recovery right was given, but not as Nanjappan, and also a few grounds are based on the quantum of compensation.
You are saying about the surety.
Surety.
Not necessarily. Nobody is going to do this.
Lordship,
Oh, that
they
Supreme Court
give
gives-
lordship nowadays. So we
One
can,
gives a pay recovery scheme. These people, they don't appear out there. How do they pay? Give them pay. The moment the recovery will be done as per the land revenue,
yes, that,
then they will know. They know it. This is being clearly given. Nothing wrong. Oh, nothing there. Only on that ground.
the other ground that filial consortium is given an interest also lordship. Then during COVID period, interest was given, whereas Apex Court has said that no interest in the COVID period.
At that point of time.
At that point of time, but the judgment, the case is of 2020, so interest is calculated.
Where is that no interest is to be given after that? That these periods should be excluded?
Yes.
Where is the judgment?
That order, right, not have, but it is there.
No, such type of orders are not there.
It is there, lordship.
No, no.
by Apex Court.
Did you place it before the learned tribunal, that order?
That order, I think,
What is the fault? No fault. Right? So your case is to be dismissed. I didn't admit this type of appeals.
Lordship admitted last week, one of my appeals.
Like this?
Yes.
No, I never
Yes,
do.
Lordship directed
Hello.
us to deposit the amount and
You
Lordship,
don't have a
because we
case
need the
here.
protection. We need that protection, Lordship.
No, what case is there? There's no case out here. If I have done it, I've done it by mistake if I have done. If you want, I have not signed, I can recall it to you.
No, Lordship. No, Lordship. Lordship we can deposit the amount, Lordship. That is what Lordship passes the order.
What do you
But
want?
let the owner come, Lordship.
Owner will come, then what will happen? Tell me.
We get that recovery, Lordship. How
Your
do we-
owner, you are to, no, at best, what order will be passed by this court? You go there and recover it. That's all. You
that
are
is,
going to get the same order.
that is already given.
Now,
That's
why you are
an-
not initiating the proceedings there for recovery?
Lordship,
You are losing on interest. You won't get any interest after depositing.
after depositing,
You won't get any interest from the owner. There is no decree to that effect.
Lordship, there also, when we go for recovery in the tribunal, there also we have to deposit. So our interest stops there also.
No, no, you have to deposit. There is no quarrel. The entire amount of 21 lakhs, 81,700 plus 9% interest we all deposited, and all these things will be done. Let it be done. But how does it help you? Except having another pendency of an effect.
But question is not of pendency, question is of right. Lordship, and
What right do you have?
Lordship, the right of recovery.
You recover. Who have asked you? The recovery has been given.
Yes.
Then
has been
What
given.
else do you require?
As
You
per
need a
Lordship,
stamp of authority.
for one
No, you need a stamp of, no, you need a stamp of authority from this court that you need to recover.
No.
Then
the
what do you
authority
require?
should be as per Nanjapan. That is what is,
Nanjapa, the Nanjapa is there, where the security people, these people were better, the owners. Now we don't have good owners now. The Nanjapa said that the owner will give us security and then it is there.
so that is what we want, Lordship. If that
I
is
am
given,
not going to pass such type of orders.
Lordship, if that is not given, then how do we recover this? Lordship,
It is given pay and recovery.
yes, Lordship.
The insurance is directed to reduce the interest amount, not to reduce, directed not to reduce the interest amount, but the insurance is directed to get. Where's the order that they can recover?
Lordship, page 31 of my memo of appeal,
Page
Para
31. Para?
55.
It also in the
Due course as
page
and the last-
Government order was placed in this.
Para 55, Lordship. Fourth, last fourth.
No. This is the observation. Then where is the direction? Insurance company directed to pay. Then where is it mentioned that you have to, they can recover?
That is only, Lordship, 55 it is given.
55 does not say so. However, the insurance is at liberty to recover accordingly, they decided in the affirmative. So this is an observation in respect to something.
That case.
But here there is no award saying that you will be entitled to recover.
I think that
Isn't
is
it?
mixed up, Lordship.
Okay. Okay.
Paragraph
This type of matter I don't issue admin at which. This is the matter of the law.
of like. So, Lordship, if pay and recovery is not given, at least this Lordship can give me that pay and recovery right.
This I need to mention in the award. That okay, that the pay and recovery.
Because actually the tribunal got mixed up in that paragraph 55, Lordship.
But making this appeal admitted will go for a long time.
Of like.
This needs to be finished up. I am not taking up this bench. Hey, इसी को बनो इसे. Yes. You want what? More money? More money, you have already got 17 lakhs. How
Lordship,
much do you want?
mother was not considered as dependent on, mother was not considered as dependent on her deceased son.
Oh, then what else do you want?
Lordship, deduction would be less from the income of the deceased.
So did you inform that you had a mother? The deceased had a mother.
Was a party and subsequently died. Mother
Who
was a
died?
party. Mother.
Mother died.
Lordship.
So therefore not given.
Lordship, there is a judgment of-
What does he say?
Then, judgment of-
That at that time mother was alive, so he
Real
would have
lordship
spent
also.
less. Huh?
Paragraph 10.
Well, does he say with that? Cannot
Paragraph
seek
10.
the benefit of the subsequent. So mother was a claimant.
Clement.
He died.
Right.
Her reference counsel is getting on the house. Filed a he of the Hickory could be judgment. And Calcutta, the council is getting on the house. The appellant submits that it's required that the instant appeal has been directed, it is by challenging the quantum of compensation awarded. Much as per him, the learned trial court, learned tribunal, while award have incorrectly made incorrect deduction of the personal expenses and have also not awarded solution. Solution not required. Solution would not happen, no? Because the mother is dead, what is there to be sad about?
Other claimants.
Other claimants cannot get, they cannot have the relief for that. Only on this. All for records. Solution you can't get. You have already got the solution, but you cannot get the parental solution. Isn't it? Can you get that on behalf of the mother? No, you can't. Because the mother is not there. She is not unhappy now. Yes, next matter. 23.
This application filed with the insurance company, the found that the DL of the offering vehicle was not valid. The CO was examined, but that was not taken into consideration by the learned tribunal.
Who died?
It's not that case, Proceed. The injury date, DL of the operating vehicle was not valid at the time of the accident. The TTO was examined. Lordship, the analogous.
Replied to the RTI. And I have brought you who replied to the RTI. He failed to establish of the tractor was invalid as he could not produce the register of issuing the driving license on the ground of destruction and thereby does not that I Mark Lea was not paid. We make it clear that there is so how much given?
Lordship, 5 lakhs 40.
So you paid that amount?
Lordship, we pay 50%. Lordship.
Why?
Lordship, because we have taken one more ground. The
We
medical
paid it.
expenditure has been given 4.5 lakhs.
Huh?
4.5. But the bill submitted is not 4.5. Bill, the amount of medical bills submitted is less than that. It's
How do you know?
2.9. Lordship. It's calculation of the bill submitted. We have to bill.
It doesn't say. Must there have been much more? You was taken to all these places,
A lot.
Brahmaputra Diagnostic, Aditya Nursing Home.
3.9, we're admitting 3.9. But not 4.5.
3.9, 40,000, 50,000. So how much does it come to?
Plus, there's one more point.
Yes, I mean,
The third point, we have taken it, loss of in the cross examination.
Hmm.
This injury was head injury loss.
deposit the 4,80,000 plus interest of 7%. That is the amount you deposit for stay. 4,80,000 plus 7%. Against the injury case number 1, where an amount of rupees 5,40,000 along with interest at the rate of 7% have been imposed, have been settled upon the appellant. The grounds of objection made by the appellant insurance company against the matter are twofold. First, that the learned tribunal did not properly appreciate the evidence of DW1 in coming to the conclusion that the driving license of the driver of the vehicle was not valid. The second ground of objection so taken is that the medical bills which were submitted were to the tune of rupees 3.90,000. However, the learned transport tribunal had granted 4,50,000 on account of medical expenses. Taking into account the above,
There's a third ground also loss.
but
Loss it. His injury was in the head loss it. In the cross examination, he has said that as he was not wearing the helmet, so he got injured in his head. So there is a little bit of contribution from him also. Because of his negligence also he got the injury.
did you reduce direct and corroborative evidence to the effect? Did you take a stand in your pleadings?
No.
Did you take your stand in your pleadings? Huh?
Lordship,
No.
probably not being taken.
I make it a point to dispose of one MSc appeal a day. Do you want this to happen like that if you don't pay that amount? That's right. Taking into account the said grounds of objection, this court admits the appeal for a record so and so. That's Next, I acknowledge. You file an IA?
Yes,
Is an application filed under so and so for stay of the so and so, amount is so and so. This court have duly taken note of that the claimant, that the appellant insurance company have challenged the quantum on the ground of an excess amount of rupees 60,000 have been imposed in respect to medical expenses, which was beyond the evidence adduced. Taking into account the above, it would be deemed that the appellant have duly admitted the amount of rupees 4,80,000 being the first. Accordingly, this court stays the impugned judgment and award dated so and so subject to deposit of an amount of rupees 4,80,000 along with interest at the rate of 7% from 7% per annum on the date of filing of the claim petition till the date of 7% from the date of filing of the claim petition. And the same be deposited within the period and 6 weeks, the amount of rupees 4 lakh along with interest at the rate of 7% from so and so. This court further, taking into account the second ground of objection, observes that in the circumstance the appellant is successful in the instant appeal in respect to the validity of the driving license of the driver. This court would pass appropriate orders for pay and recovery from the owner. I stand with you.
Also, may
Are he really serious with delivery?
I make it the analogous case, with the analogous case, made this case to calculate that which are originally admitted.
No. Come on, summary.
Like
24.
Your lordship. So there, the previous was a lordship, pensioner lordship, pensioner, retired lordship, retired employee lordship of the irrigation department lordship. And he is getting pension amount. And learned member lordship awarded compensation under the head of loss of dependency, along with the other heads. And lordship, secondly, lordship, the driver, some owner who dropped the vehicle at the time of accident. lordship,
It's a death case.
it's a death.
Who died?
The husband and the father of the
So then,
son. Husband died, and wife and the son filed the case.
future prospect not given.
So because lordship, he was above 67 years. 63, saying 63, but as per the PAN card lordship is 66 years. So in that way, that future prospect is, he is not entitled, claimant is not entitled for that.
Now, why do you want to reduce further? Not
My
giving any,
submission- my
you
submission
don't want to
is
give
that-
anything out there to these people who are, if it's a senior citizen, the insurance company treats them like that. An amount of rupees 4,84,000 is only being given, and this is the right you have given. We have already tortured them from 2018, and we are in 2025. After 7 years, now you say that he is not entitled, that these people are not even entitled to 5 lakhs. In a
Lordship,
time when
it's
any,
48,000. And lordship, the other heads lordship, it's 1,81,500.
Huh?
Other heads, 1,81,500. Lordship may admit the matter at this stage subject to 50%.
no. 181 to you have to give.
180, yes, lordship,
So that is gone. And why not 484?
because this, she's getting already, she's getting lordship, the family is getting the pension. and
For what?
From the government, and then again. the insurance-
So that would not help you. Family getting a pension from the government, they would obviously get a pension to that way. But how does the pension have anything to do with this? This will be covered by the other judgment. There are two sets of judgment. Now, one judgment said that if he's getting the same emoluments, then obviously it is there. Now here there will be monthly income. This is,
She's also getting that amount, 12,000 lordship.
then what will
12,500.
she get? Means if a person who gets a pension, he doesn't get any amount. I would have understood. If a person is otherwise being a salary, he gets something.
Double she's getting. From both
Okay.
sides.
Appeal is admitted, appeal is admitted, call for a report, steps be taken, so and so. Ms. M. Chaudhary, appeal admitted, agote likhi. Ms. M. Chaudhary, the loan counsel appearing on behalf of the appellant submits that the issue involved here is one of the grounds so taken in the instant appeal is the ground of objection of the Indian instant appeal that as the mother, but if a pensioner gets that amount, how much will the wife get? Same amount?
But that is not in there, only 12.
No, obviously it will be less.
It will less.
Then
Less.
why not this amount? Okay, 50% of here and 1,81,000. Submits that the learned tribunal, while awarding the compensation, did not take into consideration that the claimants would be entitled to some amount on account of the pension of the deceased upon the death of the pensioner, who was the deceased. The learned counsel submitted that without making therefore necessary deductions in that regard, the impugned award has been passed. Taking into account the appeal is admitted. Stay to divorce is like this. Taking in the heat on the grounds it will be like He is given subject to deposit of rupees. Four lakh 50,000 along with interest at the rate of 7%.
Another ground, this 9% is in the
How much is the interest?
9%.
Huh?
Higher.
9%.
I have taken one ground.
Okay. 9% per annum. Along with interest na lage. And deposit of 5 lakhs. It will release to you. Huh?
Not the price low. We'll take steps. We'll take steps.
Sir, I've given you. You get the order. I do.
Make this your lordship. Your lordship, the main ground is upon compensate family pension. It was introduced by the government of Assam by notification.
What is this? How much you are asking for?
Your lordship, we are ready to deposit 5 lakh. Actually,
Hmm.
there is no loss of dependency because of this, because they are already getting the amount. Your lordship, kindly come to page number 16.
50.
16, your lordship.
16.
16. Paragraph 6. It's the deposition of the PW2. May I read it?
That he has appeared on the strength of the summons issued by the BD and fulfilling the salaries of the having the What do you want to show?
Your lordship, our contention is that there is no loss of dependency because they are already getting the last drawn salary of the deceased. The family of the deceased is.
Oh, that 2017.
Yes, covered.
Bill একটু admit করে দিব হ্যাঁ bill একটু আর it's stated খালি notice issue no payment notice it is stated notice and the taking into account the grounds of objection taken the impugned judgment will be order dated so and so state till the next date full stop sport icon pending আছে কি আর এখন notice issue notice making it returnable by 26th of May icon full stay full stay
26. This is again the quantum of compensation. It's a fractionality of the TBA only and 25 lakhs, which is very high. It appears to be a disproportionately higher compensation. Fraction of the TBA and
which one
this is a case of injury. It involves a fracture of the tibia. And the compensation award is 25 lakhs, and it's very high. Disproportionately high under all heads.
tomorrow a good cricketer his tibia is fractured it will be in many crores a good cricketer tibia gets fractured it will be in many crores
But there is a lot of
what
income.
was he doing this person hello appeal to admit qualified stay 50% 6 weeks I'll to release for you stay is subject to 50% 6 weeks I
27.
one MACI yes what is your case
Wrong multiplier has been applied, lordship.
every case is wrong multiply why this time what happened
25 years of age.
huh
multiplier applied 17, it should have been 18, Lordship. And Lordship, loss of consortium awarded on the lower side.
How
Three
much?
claimants are there, only 44,000 has been awarded.
So consortium Hillel 44,000. How many are there?
Parents and one unmarried sister.
Unmarried sister will get.
Real
Did you prove that the unmarried sister was a claimant?
claimant,
She was a claimant. And she was surviving on the amount of, yeah,
brother.
and the parents were there.
That's it.
And what were the parents doing?
Friends, respect no. This.
Okay, admit koi দিব.
Step 51. My lord,
What is this? Oh, this one, the first day.
Madam.
Other side has not appeared till now. I have heard Mr. A.K. Sahiwala. This is the last disposal in my book. Heard Mr. A.K. Sahiwala, the learned counsel, appearing on behalf of the petitioner. First, none has appeared on behalf of the respondent in spite of service being complete. This is an application filed under Article 2 to 7 of the Constitution challenging the order dated 24/6/2024, passed in Ms. G, case number 16/2023, whereby the learned trial court arising out of title suit number title suit number
74 of
74/2019, whereby the learned trial court had rejected the said application, seeking amendment of the claim.
page 79.
This court duly takes note. What is the amendment you are seeking?
My lord, we are seeking amendment with respect of only small piece of land. Actually, initially in 2019, the suit was filed for a bigger chunk of land, which was not actually the subject matter of the suit. And they have paid initially when the case was filed.
Now, what are the prayers you are seeking?
My lord.
Plaintiff is the owner of the suit land described in Schedule A. Past possession of the Iman property by giving to the plaintiff by evicting the defendant, so and so. These are the two prayers.
My lord.
This court have duly taken note of that in the said suit, summons have not yet been issued.
But-
Taking into account the above, is the opinion of this court that the learned trial court ought to have allowed the said amendment application and proceeded with the said suit. That view of the matter. Wait. Why the government is a party?
Because, my lord, the property has been mutated in name of some other person. My lord. That is why we made a party. We issued a section 80 notice.
This is subsequent to the filing of the suit.
My lord, yes.
Now you want to bring that aspect into the amendment.
No, man. Recently, we made a government party, but section 80 notice was not there.
See, the court outrightly dismissed the suit. They came to the High Court, High Court said, no, now you issue and then let the suit proceed. We put a section 18 notice and then we came up with an amendment.
And now you want to impede the state government.
Yes, the government was already implemented, man. Government was already there, but section 18 notice was on. Section 18 notice was not issued initially in 2019 when the suit was.
Mr. Sahel,
filed.
I don't want to be involved in this type of mess. This is absolutely not. How can a suit at all be filed without a section 8? Either you seek a waiver because the initial jurisdiction of the court is not there.
Correct.
And means introspectively, if this order is being passed by this court, I think I can't help it. Let it come up before any other court.
Because, my lord, what has
This
happened
is too
already,
much. This
already,
No, no, why I'm asking you? A suit is filed in the year 2019. You filed the amendment application in 2024. Summons have not been issued. Isn't it the strangest thing I've ever heard in anywhere? Has any of the civil lawyers ever heard of something like that? Summons not issued of a suit from 2019 till now. There's something wrong. Therefore, I am asking you, what are the reliefs you are asking? Should I give you the doctrine of relation back or not? Because of the fact that an amendment, when it is done, if I have to apply the automatically amendment will go to that particular date. And with that date, your suit gets regularized. How do you take care of these situations? Why you're not withdrawing the suit and filing a fresh one? Must be some good reason.
what had happened.
No
Okay.
one can conceive of Mr. Sarawala that 2019 suit till 2024 summons have not been issued. Why? There must be something. Couldn't it the provisions of order 7 rule 7 kick in? Or order 7 rule 9?
Other which way, my lord,
Order 7 rule 11 E? All these provisions will kick in. And how is it possible that this is going for the last 6 years and now you file an amendment of it? Why you are not withdrawing it if you want to amend? This type of matters cannot be allowed.
so my lord, at least, your lordship intervenes and passes an order, I may be given a liberty and withdraw and then file it. Ultimately, my purpose will be solved.
Huh?
My purpose will be solved, my lord, because I will be able to file a suit. Provided that limitation part I have to see, my lord. That is the.
A limitation. That is why I'm saying, why should I apply the doctrine of relation back?
No, my lord,
Because
what
the
had happened-
moment I give you, because this is not a case for recovery of, this is a suit for recovery of possession. If it's a recovery of possession, then why the limitation will apply? If you are the owner of it,
Yes.
unless the other side pleads adverse possession. But by your conduct, you have already made it 5 years, you have already assumed that he is adversely possessing against you.
My lord may come to page 45, my lord, for a moment.
No. This matter will go. When do you want it?
Okay, my lord,
This is the matter again on 3rd of April 2020. We'll require time to think about it. But we should. Very difficult.
Item 28 for hearing under 51 rule 2 CPC.
No. This is matter some other day.
Some other.
When do you want it?
Any day.
Seven?
Hearing for the matter,
7th of April? 7th of April?
Seven.
The matter on 7th of April 2020.
29.
Order 41 rule 11?
Yeah.
Not today. 9th of April 2020. 9th of April. 9th of April.
Orders item 30.
Service complete.
Yes, but in compliance with the order.
Service complete.
Yes, but
Service complete. LCR received is the matter for hearing in the usual course. Liberty given to both the parties to file affidavit file application for early hearing.
31.
Who wants to go where?
From an instruction receipt, a memorandum of understanding was executed in dated 19 March 2025 receipt, and as per the memorandum, both parties want to issue the case. This is timely.
He doesn't know. Oh, no, not me. Then both of you file an application. Jointly file an application. Okay.
But you can look at because of the stay order receipt,
He doesn't know. It's true. Why didn't you tell him? You know him. His name is appearing. Okay, list this matter again on 4th of April 2025. First of, in April 2025, in view of the fact that the council appearing on behalf of the respondent has submitted that there has been an amicable settlement between the petitioner and the respondent. Mr. S. Islam appearing on behalf of the petitioner submitted in instructions.
32.
We are opposing to this application.
By Mr. D. He left us now.
Okay. Now, what is there? This matter I noticed when almost a year back.
Yes. In fact, my lord, what happened, my lord?
And
the-
even now the matter has not been disposed of.
It has not been disclosed.
Why?
But here, one contention in the FAO, where my lord, our one application under Order 39 Rule 4 was not considered by the court only on the ground that the suit was kept in abeyance, and therefore that application is also kept in abeyance. Now, initially, my lord, what happened? The plaintiff, my lord, filed a suit in respect of,
I know that
yes,
there is
Now-
an order passed by Justice Indra Shah which has
Yes.
caused all
Yes.
the problem.
and my lord, the other tag matter, the IA, my lord, we have filed a recall application. To recall their application, where we have said, my lord, that initially that application of substitution, we objected to that substitution application. Where we have said that we have no objection now, if the plaintiff, they
Okay. Do you file
Well,
an IA to CRP 97?
CRP 97. CRP 97
there-
recalling that order to the extent, my lord, that the objection which we have filed in with regard to the substitution of the executed in place of the plaintiff. Now we have said that this, in terms of the judgment of this Honorable Apex Court, that the substitution can be happened. Now that's a order which was passed by this Honorable Court upholding the order of the civil judge, keeping up the order that has kept the suit in abeyance. Since 2012, the suit is in abeyance. Now, my lord, because before this suit was kept in abeyance, there is a status quo order passed in respect of this case. And now our application under Order 39 Rule 4 also cannot be taken
So
because it's
therefore, first we need to take care of this IA 922/2020.
my lord.
It being taken there, isn't that?
922 is the IO in the FAO. That is under the
And
Order
which one? 2553.
955.
Have the other side filed their objection?
They have
Yes, my lord, we have filed our objection. My lord, some difficulties, my lord, which perhaps, my lord, I need to point out, my lord, whenever my lord is hearing the matter, if my lord hearing it today. My lord, I find, my lord, the first, my lord, the order is of 2014. My lord, whether it can be recalled now, and my lord, there are two civil revisions, my lord, which were disposed of, my civil revision as well as my learned friend's civil revision.
Now, this application has been made, my lord, in one of the civil divisions. They asked for a recalling. And recalling means, my lord, the entire civil division will come back, will have to be heard again. And
I
the
think the best option would be to recall it.
my lord,
And then either of you will go to Supreme Court. So
my lord,
then
whether
the
that will be
Supreme Court, let
possible
the
or
Supreme
not,
Court settle it.
my lord, whether that will be
In fact, I may say one thing.
possible or not, may I just, my learned friend,
This
may I
same
just,
plaintiff, my lord, they have filed one more suit, that is title suit 47. In respect of the shares that
But
was held by
that's
the mother.
different.
In that, my lord, the substitution has been done. And in the same terms as that was laid by the Honorable Supreme Court. in
No,
the
that's
Nava.
because I was already a party there. That's not, my lord. But, my lord, the difficulty is here.
We'll hear this matter some other time.
Very well, my lord.
I think
Well,
last time I thought about disposing of my roaster chilies. I think this is the only way out.
That's the only way.
No, my lord,
Order,
recalling, my lord, will also be
interest
difficult.
of justice has to be done.
My lord, recalling will
Then
also
the
be
Supreme Court
difficult.
judgment to be.
My lord, recalling will also be difficult because of the fact,
Because a
benefit
suit cannot be put into
my
limbo
lord,
in this manner.
Absolutely.
my lord, I also, my lord, would have agreed, but the only
So I
difficulty
think
is,
we'll
my
do
lord,
that.
this
But not
matter,
today. Today, I don't have the time for that. So we'll have it
In
when.
fact, this recalling would benefit.
Well,
the
then kindly, my lord,
plaintiff because
keep
it was
it.
their application otherwise.
So
My lord,
we'll
Wait for substitution.
my lord will hear me, my lord, when I
file
come. My lord,
When do you want it?
my lord, if possible, my lord, on the 3rd of April, 3rd April, my lord, if possible.
3rd April, not possible.
Then, my lord,
Let it be somewhere in the month of May.
then, my lord, in May, my lord,
It's a matter on 7th of May.
7th of May. Very well.
We'll have it on 6th of May.
6th. Very well.
33.
My lord, 7th, my lord, will 7th be a difficulty, my lord? My lord, will 7th be a difficulty, my lord?
7th is a Wednesday. This matter will take some time.
8th we can make, Mr. Manager.
Very well.
8th,
No,
6th.
no,
8th, I won't
No,
take
no.
up.
Very
I
well,
have
my lord.
Other matters.
Then 6th, my lord, is putting it. Very well.
33.
There's any urgency? Anybody has any urgency? Oh, so many. What is this? What is the urgency? What is the urgency? So many CRPIO. Is item number 53, who is holding it? Every 53. 53, whose item? Is there a stay in 53?
My lord, item number 38, there is a stay order. Item number 38, my lord.
38. Stay order is there.
My lord. Service already completed, it may be come up for admission.
Taking into account that the service is complete, 38, leaves the matter for admission on 23rd of April 2025. Interim order passed earlier shall continue till then. Whatever silent over there.
My regard to item number 36, your lordship. Seeing the urgency of this matter, your lordship has asked me to take dusty service upon the respondent, your lordship. I
You've
have
taken
Lordship.
affidavit pertaining to dusty service not received.
Yes, also I have filed the affidavit, your lordship.
When did you file it?
Your lordship, I have filed earlier, your lordship, but there was some defects. It has also been rectified, your lordship. And your lordship, the endorsement copy is annexed with my office copy, your lordship.
Is anybody appearing?
No, your lordship, no one is appearing. Every time, your lordship, I have not met my son for 1.5 years, your lordship. My interim prayer has not also been not been considered.
Okay, this is CRPIO 477. This is for what?
Your lordship, my interim prayer has also not been considered.
What
for
is the matter about?
Lordship, guardianship matter.
Oh, yeah.
Your lordship, for 1
We
year.
do one thing. Let us have it on 3rd of April. 3rd of April?
Your lordship, on 2nd of April, the next date, before vote is on 2nd of April, your lordship. If your lordship may just pass this order that on the next date, my interim prayer may be considered, your lordship.
By there?
On next date,
By this court?
yes, your lordship. Yes, your lordship. No, by the lower court, the family court.
How do I say so without looking into the file?
And you're also
Okay,
for the last 1 year, you're.
counsel appearing on behalf of the petitioner expresses urgency. This matter again on second of April 2025.
Item 45, Lordship. Item 45, Lordship, can simply pay up Lordship for directing the registry of this honorable court to release the deposit amount 8,85,000 which has been deposited by the appellant in the registry of this honorable court in terms of order dated 13/12/2012 in favor of the applicant, Lordship.
Who is
Any
appearing
appeal
for the
of
other
dispose
side?
of, Lordship.
Who is appearing for the other side? Okay, item number 45 to be listed on 28.
Awesome.
Item 34. Item number 43.
53. What is the
43.
respondent appeared? Interim is there. Interim is there.
No, interim is.
What do you want?
Because when the order speaks, next day it speaks for 11/5.
11/4,
11/4.
Oh, yes.
Lordship, that is.
Yes, I remember. You wanted some amendment or what was
No,
that?
Lordship, we wanted the recall of some orders. We were not allowed to, because we were absent, we were not allowed to cross-examine the PWs.
He objected a lot. Hello. Item number 43. Do you want it? We want it on 9th of April?
On 7th, will it be continued? 7th.
7? 43 to be listed on 7, comma, on which date the interim order shall be considered.
Lordship, item 34, Lordship. The interim order may consider.
34. Transfer.
Yes, Lordship.
Who wants to go where?
Lordship, Tezpur to Jorhat, Lordship.
She wants to go from Tezpur to Jorhat.
You're the husband. Go to Jorhat.
Point out certain things.
I don't take much time. I don't go for that. Then why are you troubling? You want the child. You want the wife back. Go there.
And the child, Lordship. I have a little child.
Go there. Go to there. Transfer. You file your written statement on Wednesday. You have not filed your written statement.
Yes, that is, yes, already bottom record, Lordship. The ex parte proceeding. I will have to file my written statement.
Okay, you file your written statement. Transfer there. You go and file and records be transferred by 26th of May 2025. Transferred. What is there to hear?
He came to this court on 21st, my lord, and on 22nd, next day on page 2. He was able to come 307 kilometers, not go 150 kilometers from.
No, I'm not on that. What does she do?
He's an go-grade officer in the Indian Air Force, whereas I'm a.
You're an officer.
Yes, officer.
Employee, Lordship.
Oh, that's good. Dismissed. File your written statement.
I have a child, Lordship.
No, so what?
I have a child.
So what?
I-
Do you
I-
go to
I am
do
living
you
in
go to the office or not? Do you go to the office or not? Fantastic.
I have a child, Lordship. and-
Okay, it was 34 to list the matter again on 9th of April 2025. I'm not extending this interim order.
Till then, Lordship.
No.
Item 41. Service is complete, my lord.
The service being complete with the matter for admission on 25th of April 2020. Why? 25th of April 2025. Is there an interim order? Interim order past service will continue till.
Your Lordship, item number 48. It's a new IA that I have filed and disposed of CRP. Your Lordship, what has happened here is that Your Lordship directed the judgment debtor to deposit an arbitral award before the executing court. Now, what has happened is the executing court does not have a bank account in their name. So though they have prepared the demand draft, it could not be given effect. So we are seeking a
You
modification.
have to finish your submission within 1 minute. 30 seconds. No.
That's
After 30 seconds, I don't sit.
only, that's my only prayer. I'm seeking a modification.
30 seconds over.
Come date, your lordship.
Item number 36.